ఇప్పుడు ఇది వెయిటింగ్ లిస్ట్ తీసుకురావాలట. ఈ రెండు వెయిటింగ్ లిస్ట్ ఇక్కడ డేటు అలా ఆగస్ట్ ఫస్ట్
రమణీయం ఉందండి.
వెంకట్రావు గారు నమస్తే సార్.
నమస్తే 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 నమస్తే
నమస్తే సార్.
నమస్తే.
చెప్పు
ఏ
రోజు నుంచి అయితే ఆ రోజు నుంచి వస్తుంది.
నమస్తే సార్.
నమస్తే నమస్తే.
ఒక చెప్పాను.
నమస్కారం. సాయంత్రం ప్రసాద్
రాఘవేంద్ర సార్, గుడ్ ఆఫ్టర్నూన్.
మాస్టర్ రాజేంద్ర ప్రసాద్ గారు నమస్తే సార్.
My greetings to Honorable Vice Chancellor of Andhra University.
He is joining, sir. He is joining.
Yeah.
సార్ నమస్తే సార్. చంద్రకళ నమస్తే. చంద్రకళ మేడం, రాజేంద్ర ప్రసాద్ సార్, వెంకట్రావు సార్, అందరికి నమస్తే సార్.
నమస్తే నమస్తే.
లక్ష్మి మేడం. అది ఆడిబులా వినిపించి. సుమిత్ర మేడం అందరు మ్యూట్. ఓకే మేడం. ప్రసాద్ రెడ్డి ఫోకస్ చేస్తారా?
గుడ్ మార్నింగ్ అండి. గుడ్ మార్నింగ్ వెంకట్రావు గారు, రాజేంద్ర ప్రసాద్ గారు.
నమస్తే నమస్తే.
వెరీ హ్యాపీ టు సీ యూ.
It's always a privilege. Okay.
నమస్తే మాస్టర్.
నమస్తే నమస్తే ప్రిన్సిపల్ గారు.
నమస్తే సార్.
రాజలక్ష్మి గారు కనిపిస్తున్నారు.
Sumitra, I can share one secret with you. Today is actually the birthday of my biological mother. Today is my mother's birthday.
అలాది కదా. అదే అదే చెప్పు. అదే సరిపోయింది. వెంకట్రావు గారు గుడ్ మార్నింగ్ చెప్పండి. వెంకట్రావు గారు అదే కృష్ణమోహన్ మీకు గురువు గారు వెంకట్రావు గారు, ప్రొఫెసర్ వెంకట్రావు గారికి నమస్కారం.
నమస్తే.
నైస్ టు సీ యూ. మా గురువు గారు
always a privilege.
ఓకే.
ఆయన జాయిన్ అయ్యారు. P.S Rao గారు అంటే ఆయన అసలు గెస్ట్ రాలేదు కదా.
Venkataraman Endowment lecture, Professor S.Venkataraman.
P.S Rao garu. I mean, my text. Welcome. బెమ్మరాజు శ్రీనివాస్ P.S Rao అని ఉంటుంది. బెమ్మరాజు అని చూడండి.
Namaste, Sumitra madam. I am P.S Rao from MMTC.
నమస్తే అండి.
I am your student for PhD. I am in my second year.
నమస్తే. గుప్తేశ్వర్ గారు వచ్చారా?
Yes, ma'am.
సార్ గుప్తేశ్వర్ గారు.
Yes, sir. Yes, ma'am. This is P.S Rao. I'm not on video.
మాస్టర్ నమస్తే అండి. నమస్తే సార్.
Namaste. I can't miss when you invited me.
సార్ నమస్తే సార్. మేము లాగిన్ అయ్యాం సార్. మీరు
నమస్తే మేడం.
మీరు పనిచేయండి. మీకు
నమస్తే అండి. జేఎల్ఎన్ మూర్తి, ఐసిఐడిఆర్ హైదరాబాద్.
సార్ నమస్తే సార్. వైస్ ఛాన్సలర్ గారు, సార్ సార్ రిజిస్ట్రార్ గారు నమస్తే అండి. పిఎస్ రావు గారికి చిన్న టెక్నికల్ ఇష్యూ ఉందండి, ఆయన జాయిన్ అవుతున్నారు. 2 minutes.
Absolutely no issue at all. Okay.
Thank you.
ఈ లోపల వెంకట్రావు గారు ఏమన్నా మాట్లాడతారేమో చూడండి. కేశవరావు వెంకట్రావు ఇద్దరు ఉన్నారు.
కేశవరావు జాయిన్ అయిపోయారా?
ఇందులో వాయిస్ వినిపించింది, మరి మేడం గారు చెక్ చేయండి.
రాలేదు.
మా మాస్టర్ గారు ఏదో చెప్పండి. వెంకట్రావు గారు, గురుగారు
వెంకట్రావు గారు సార్, ప్రొఫెసర్ వెంకట్రావు గారు.
Am I audible?
audible.
You are audible.
See, I only told. I'm reminded of what Ernest Hemingway had said in one context. So he said, when the heart is full, the lips will be silent. And when I look at all your faces, my heart is full. And therefore, my lips will be silent. And the reason being, today is my biological mother's birthday. And we are having an endowment instituted in the memory of the one and only Professor Venkataraman and the one and only Dr. Pamela Srinivasa delivering that. Now, what better birthday gift can I give to my mother? Okay. Therefore, I'm also anxiously awaiting to listen to the erudition of Dr. P.S Rao. Thank you very much. Okay, thank you.
Sir, this 4th August is also technically the birthday of your alma mater, the law college. So
that's right. Thank you. That's.
మా ఆయన దాన్ని ట్రై చేస్తున్నాను, ఇంకా తెలుస్తుందా? పిఎస్ రావు. పిఎస్ రావు ఆయనకి మెయిల్ మళ్ళీ పెట్టామా?
Okay now?
Sir?
Am I there now?
Sir.
Yes, sir.
Welcome to you, sir.
Thank you very much. I'm just sorry for the delay because this normal emails I use is P.S Rao at yahoo.com. So you are communicating with me on my wife's email ID, which I also have, of course. So that's why I was putting the other number, and then I found out that I have to go to that other one. Got it. Anyway,
He has his wife's
let's not
ID.
lose any more time. Then let me just get on top.
Good afternoon, ma'am.
Sir, I'm extremely sorry, sir. I should have sent it to your other.
No. This is fine. Just I'm explaining the delay. That's all.
Good afternoon, ma'am. I'm Padmaja.
Good afternoon. Sir, Prasad
Good
garu.
afternoon, sir. Good afternoon to.
Sir, the
Yeah,
guest
Prasad
has
garu.
arrived. P.S Rao garu has arrived, Andy.
Okay.
Honorable Vice Chancellor Prasad Reddy garu and Registrar sir.
Registrar garu are there.
Sir.
Prasad Reddy garu, Honorable Vice Chancellor, and Registrar Professor Krishna Mohan garu.
Good afternoon, Prasad Reddy garu and Registrar garu. I'm from Padmaja from All India Radio.
Welcome in.
Good afternoon.
You're welcome, sir. You're welcome.
Song. Mute. Sir, we will start the song with a chinna song, and it's not even prayer. So at the outset, we are happy to play a song on our law college, sir. This is a law college song. This is authored by Professor Rajalakshmi and sung by the Department of Music people. Please start.
Vandanam Abhivandanam Vandanam Abhivandanam Vandanam Abhivandanam Nyaya Vidya Alayaniki Vandanam Shubhavandanam న్యాయశాస్త్ర ప్రాంగణానికి వందనాల తోరణం చిరుచందనం మా వందనం చిరుచందనం మా వందనం
చైతన్యకి కూడా
విశ్వకళామ తల్లికి న్యాయ సుద్దుల ముద్దు బిడ్డవి ఆంధ్ర విశ్వకళామ తల్లికి న్యాయ సుద్దుల ముద్దు బిడ్డవి నీదు ఒడి మా బడిగా చేసి విద్య గుడిపే తల్లివి గుడిగా మారిన తల్లివి నీకిదే మా వందనం వందనం శుభవందనం నీకిదే మా వందనం వందనం అభివందనం వాసికెక్కిన న్యాయమూర్తుల వాడి కల్గిన న్యాయవాదుల వాసికెక్కిన న్యాయమూర్తుల వాడి కల్గిన న్యాయవాదుల ఖ్యాతిగాంచిన రాజనేతల దారిపరచిన గురువరేణ్యుల మూలమే నీ నిలయమో నీకిదే మా వందనం వేల వేల వందనం వేల వేల వందనం కనుల పొదిగిన జ్ఞాన ఖనివని సన్నిధాన చేరిన ఘనుల పొదిగిన జ్ఞాన ఖనివని సన్నిధాన చేరిన నీ సన్నిధాన చేరిన అర్థులం విద్యార్థులం మమ్మేటికేటికి సానబెట్టగా కోన కోనలకేగుదాం నీ ఘన చరిత్రను చాటుదాం నీకిదే మా వందనం వినయముగా మా వందనం నీవు పొందిన వాసిని నాసిగారు పొందనీయం నీవు పొందిన వాసిని నాసిగారు పొందనీయం నీకు చెందిన కీర్తిని అపకీర్తి కాబోనీయమమ్మ నీకు చెందిన కీర్తిని అపకీర్తి కాబోనీయమమ్మా ఇది ప్రతినమాది వ్రతము మాది నేటికి నాటికి ఇది ప్రతినమాది వ్రతము నేటికి ముమ్మాటికి వందనం అభివందనం వందనం శుభవందనం వందనం అభివందనం వందనం శుభవందనం వందనం శుభవందనం వందనం
Good afternoon to everybody.
Good afternoon, sir. Good afternoon, ma'am, and good afternoon to all the members there.
I welcome all the distinguished guests, our Honorable Vice Chancellor, the endowment lecture guest who is going to deliver endowment lecture on this auspicious August 4th, the foundation day of this particular law college. Last year we celebrated 75 years celebrations, and this Professor S.Venkataraman Endowment lecture. Actually, in Andhra University Law College we have two endowment lectures. Professor S. Venkataraman Endowment lecture, which was instituted in 1980, and 2 years back, in the name of Justice Chalameswar, the former Supreme Court judge and the distinguished alumnus of this college, another endowment lecture was there. So, in the series of this endowment lecture, which was instituted in 1980, this is the 6th lecture. So far now, in Andhra University, we have this particular distinguished endowment lecture in the name of Professor S. Venkataraman, who was Principal of Arts, Commerce and Law College in 1940s and 50s. And he was a principal for a long period. He was well known in his oration and a popular teacher. He is a prolific writer. He wrote several books. He is an authority on Hindu law in those days. And his students, scholars, and well-wishers instituted an endowment lecture way back in 1980. In the series, Professor Justice P. Jaganmohan Reddy, who was one of the 13 judges who delivered the landmark judgment in Keshavananda Bharati, which changed the entire course of the Indian life, he gave the first endowment lecture on the concept of federalism. The second endowment lecture was given by Justice K. Ramaswamy, who is another distinguished alumnus of this particular college, who talked on this particular concept of equality. Then the third lecture was given by Professor P.S. Murthy, the well-known international jurist and popular teacher, and the teacher of all our distinguished alumnus, including our present speaker, Dr. Kamaraj Srinivas Rao. So, he is an authority on international law. He delivered a lecture on secularism. So the fourth endowment lecture was given by Justice Law Nageswara Rao garu on right to privacy. In 2019, the fifth endowment lecture was delivered by Justice Chalameswar on rule of law under Indian Constitution. Now, with the blessings and auspicious well-wishing of our university authorities, we are able to organize this sixth endowment lecture, for which we invited Dr. P.S Rao garu, who happily and readily accepted to deliver the lecture. And we are so fortunate, sir, to hear you, your erudition, as our Venkataraman garu just now mentioned. So Venkataraman garu in the recent times compiled a book on the essays of Professor Gupteswar garu, where the famous quotation of Professor S.Venkataraman quoted, nowadays there are extinguished jurists, but not distinguished jurists. Actually, distinguished jurists were naturally extinguishing from the. So we are now we are becoming so. What we say vacuum is there in the academic institutions. So today we organize the endowment lecture. Our present speaker accepted to deliver a lecture on international rule of law, problems and prospects, and actually, as we know, rule of law is such a dynamic concept without which civilized society cannot survive. Rule of law is equally equated with dharma. Rule of law demands all are equal before law, and right from prime minister to constable, all are equal. How high soever you are, law is above you. Dharma rakshita rakshitoho, dharma protected protects. The Indian constitution also embodied rule of law through right to equality. But here, as far as the rule of law concept in international law is concerned, for a long period, international law was not considered as a true law. The positivists supposed international law was merely a positive morality, or it is a vanishing point of jurisprudence. But Article 38 of International Court of Justice put a death knell to the positivists. Now our P.S Rao garu, a real diplomat for the last 50 years, who is actively engaged in, who is the direct eyewitness of the developments in international arena and regarding the protection of rule of law and the challenges to the rule of law and the protection of rule of law. He was a diplomat for not only for India, to several countries. Now his distinguishment can be understood that now he is at the age of 80 years, special advisor to Attorney General of his state of Qatar. So he is former member of International Law Commission. When he was acting judge of this International Court of Justice, I attended a seminar organized by human rights activists in Delhi, where he was invited as chief guest. I was so fortunate to be there as one of the participants of the particular seminar. Sir, now I invite for this prestigious S.Venkataraman Endowment lecture, our Honorable Vice Chancellor, Professor P.V.G.D. Prasad Reddy garu, to preside over this particular endowment lecture. And whenever our department and our college approaches the university authorities, our Vice Chancellor readily accepted to organize and arrange these type of academic activities. Last year also, we invited Vice Chancellor, we invited Vice President of India to be the chief guest for this Platinum Jubilee celebrations, where all of us, including our distinguished alumnus and the associates with law college, attended that program and made it a grand success. And during the tenure of the small tenure of Professor P.V.G.D. Prasad Reddy as Vice Chancellor, Andhra University Law College was able to organize 3 endowment lectures. Now this is the 4th one, and we grandly celebrated our Platinum Jubilee celebrations with the fullest cooperation of our university administration. For that, thank you very much, sir. Now I invite Professor P.V.G.D. Prasad Reddy garu for this endowment lecture to preside over the function. I also invite our dynamic registrar, Professor V. Krishna Mohan to grace the occasion. And I invite our principal, Madam Sumitra Garu, to be on the dais on this particular auspicious occasion. And I invite Dr. Tamara Srinivas Rao Garu to deliver his endowment lecture. Thank you very much, sir, for giving me this opportunity to introduce. Over to Prasad Reddy Garu. So I am handovering the proceedings to Prasad Reddy Garu.
So good afternoon, ladies and gentlemen. I'm delighted to join the rest of the university in welcoming Dr. P.S Rao Garu, a proud alumni of Andhra University Law College, and Special Advisor, Attorney General Office of Qatar, Ad hoc Judge of International Court of Justice, to this very proud Professor S. Venkataraman Endowment Lecture, which is in fact a great motivator for the faculty, students, and scholars. Ever since the law department was established in Andhra University by Sir C.R. Reddy way back in 1945, and which was inaugurated by Justice Amaravati. It has been maintaining very high standards in academic and co-academic activities. And in fact, the Andhra University has awarded law degrees to more than 15,000 graduates under this college. And many of them have exhibited exemplary talent, whether it is legislature, executive, or judiciary, holding coveted positions, and they contributed their best to bring laurels to themselves and to the university. Their achievement as successful lawyers in Supreme Court, High Court, tribunals, and as excellent faculty in the academic field, and all of this has been a great motivation to the present generation of students. And some of the prominent alumni of the college who brought laurels are former judges of Supreme Court, Sri Jasti Chalameshwar, Chief Justice of Delhi High Court, Justice Rohini Madam, and Mrs. Bhanumati, Registrar General of AP High Court, Justice DVSS Somayajulu, Justice B. Devanand, and former Election Commissioner GVG Krishnamurthy, late D.V. Subbarao, Chairman Bar Council of India, and in fact, Dr. P. Srinivas Rao, today's guest, and Professor S. Rao, and many more as the list goes. The college had outstanding jurists and legal luminaries as members of the faculty, and some of them include Professor Venkataraman, Professor G.C.V. Subbarao, Professor Balasubramaniam, Professor Gopalakrishna Sastri, Professor S. Ramachandra Rao, Professor Lakshman Rao, Professor B.S. Murthy, Professor Gupteshwar, among others. This institution was a part of Andhra University College of Arts, Commerce and Law, and in fact, it became an independent college during 1991. As we all know, the successful journey of AU Law College into its Platinum Jubilee, which was celebrated last year. And in fact, this celebration, in fact, is a recognition and a reminder about the institution's responsibility to set new goals for the future. And as a college, this has been ranked in the top 20 of NIRF and also top 20 in the survey that was released by India Today very recently, which is nothing but a recognition and a reminder about the institution's responsibility to set new goals for the future and scale up their academic levels. Coming back to today's topic of discussion by honorable guest. be you so high, the law is above you. The principal part of rule of law has come to represent the powerful idea that even politicians and monarchs are bound by the law. However, in the age of powerful corporations and international cyber threats, and also support of authoritarian leaders, in fact, the rule of law appears to be under great threat all over the world. There cannot be arbitrary deprivation with reference to human rights. In this regard, we find that our Constitution has guaranteed many fundamental rights and provided a constitutional mechanism to secure the enjoyment of these so-called rights. While this is so, one of the curious questions of criminal importance is to know if this concept of rule of law finds any space in the international law. So, a pertinent question to inquire would be, to what extent international law serves the rule of law and help in upholding the individual freedom and well-being of people, or does it shelter for unlimited power of national rulers? This is one of the important query, because human rights violations across the world, particularly in conflict situations, is a matter of great concern. Should the ideal of rule of law be left to be a national feature alone? Does the United Nations deliberate on the critical importance of rule of law doctrine within the scope of international law? Such questions, in fact, are questions of pragmatic importance to be explored and to be answered if at all the people across the world are to feel a sense of security despite living in a world of conflicting interests. In light of this, arranging today's lecture to obtain the expert insights on the topic of international rule of law from the jurist of international stature and whose juristic competence was availed by the International Law Commission itself, is a rare and precious opportunity for all the listeners to get very richly enlightened. I once again express my gratitude to Dr. P.S Rao garu for accepting the invitation from Andhra University College of Law to deliver today's endowment lecture. And I am sure that the entire faculty, the students and scholars of this department will get all the required inspiration from today's cherished lecture. And I wish you all the best. Thank you so much. Let me extend a very warm welcome to today's chief guest. Thank you, sir.
Thank you very much, sir.
Sir, with the permission of our president of this particular endowment lecture, now I invite our principal, Madam Professor Sumitra garu, to introduce Dr. P.S Rao garu.
Yeah. I request our principal Sumitra Madam to introduce the chief guest to all the audience. He is known to everyone, but it's just a customary to introduce the chief guest. Otherwise, the world over, he is known a great personality, and I request the principal to formally introduce him.
Thank you, sir. President of today afternoon's function, Professor P.V. Prasad Reddy garu, the Honorable Vice Chancellor, and Dr. P.S Rao garu, the chief guest of this evening's function, the Registrar of Andhra University, Professor Krishna Mohan garu, and the members of the Executive Council, principals of the constituent colleges, deans and directors, heads of the departments, and my esteemed colleagues from the Law College, and Dr. S. Ramarao garu, and then Professor R. Venkatrao garu, Professor Rajendra Prasad garu, and all the other dignitaries. And there are some delegates from outside India also, and members of the bar and the bench, and then other teachers and students from the entire university and especially the law college, the present media. And in fact, it's a matter of great privilege for me to introduce the chief guest, Dr. Pemmaraju Srinivasa Rao Garu. Then on this occasion of the endowment lecture, Professor S. Venkataraman Endowment lecture, as already mentioned, we have invited Professor Dr. P.S. Rao Garu, and he has very readily agreed. And the distinction of today's lecture is that Dr. P.S. Rao Garu is a direct disciple of Professor S. Venkataraman. And he would be the most appropriate person to deliver the endowment lecture and also to speak about Professor S. Venkataraman. And then Professor S. Venkataraman, as he was known as a legendary teacher, in his name, the endowment lecture was instituted, and now we are here. Dr. P.S. Rao Garu is here to deliver the lecture. And I take this opportunity to formally introduce him. And I keep telling my students that if I go on, if I start giving the full introduction about Dr. P.S. Rao Garu, probably I will take 1 or 2 hours. So let me be very brief, as brief as I can. And because he has such an illustrious career in international law, probably over 50 years of his life he has spent in this field in international law. And Dr. P.S. Rao, he, born in 1942 in Andhra Pradesh. He did his BA from Andhra University, and then BL and ML from Andhra University, and then has done an LLM from Yale Law School 1968 and JSD from Yale Law School 1970. And then he has played very distinguished roles in the field of international as judge, arbitrator, counsel, advisor, negotiator, visiting professor, and consultant on international law in international relations. And some of his probably great achievements could be, and he has been an arbitrator in the matter of Enrica Lexi incident between India and Italy, and he was a senior advisor for the state of Qatar at present. Before the International Court of Justice, The Hague, and then he was a judge, Permanent Court of Arbitration, in the case concerning the maritime boundary dispute between India and Bangladesh, and he was appointed as arbitrator in the dispute between Libya and Switzerland, and he was the judge ad hoc of International Court of Justice, and then he has also provided expert opinion on various topics, jurisdictional immunities of states and their property, and then he has been a consultant and he has also prepared a consultant report on Indian environmental regulations, and he has been the president of the Institute D. Dryad International, that is Institute of International Law, during 2015 and 16, and vice president of the same institute during 2013 and 15. And he was the chairman of the UN International Law Commission during 1995, and was also the chairman of the drafting committee in 1997, and he has also acted as a special rapporteur. And then he, before he started his career before the United Nations and other international organizations, when he was the additional secretary and the legal advisor of the Ministry of External Affairs, Government of India, New Delhi, between 2001 and 2002, and he was the chief legal advisor of Ministry of External Affairs, Government of India, between 1985 and 2002. And then he was the leader of several bilateral negotiations between India and other countries and was responsible for drafting and negotiating many treaties. And then he has been the chairman of the panel discussion on several aspects, disarmament and centennial celebrations of first Hague Peace Conference, etc. And let me quickly mention the other achievements of Dr. P.S. Rao Garu. And he has authored several books, and one amongst them is most important is The Public Order of the Ocean Resources, a critic of contemporary law of the sea, published by the MIT Press, Cambridge, Massachusetts. And then he has also delivered several opinions in several cases. Separate and dissenting opinions have been very important in developing international law jurisprudence. And then he has submitted several reports to the International Law Commission. He was chairperson of the drafting committee. And then especially regarding the transboundary damage from hazardous activities, and then on the international liability for injurious consequences. On that, he has done extensive work and then submitted several reports. And then there were many chapters he has contributed to edited volumes, and probably reading them out, all of them may not be possible now, sir. And there are so many. And there are also articles published in international law journals, and very serious research articles published by him. And his research acumen and aptitude is such that even for the lecture also, I mean, I knew how seriously he was working. And then above all, being an illustrious and the most distinguished alumnus of this law college, sir. And then what makes him stand out from many others is his humility and compassion. So his dedication to his work, sir, generations of students, and especially the students of this law college, they're going to be inspired by you, sir, and by your erudite speech. So we look forward to listen to you. And thank you very much for this opportunity. So,
Very nice introduction, madam. So now, okay, we are in fact, moving into the most important part of today's program. I would put a request to our chief guest, Dr. P.S. Rao garu, to take over and deliver the lecture.
Sir, can I say one sentence? Just one sentence. So, Dr. P.S. Rao garu, since you're the direct disciple of Professor S.Venkataraman, as you were mentioning on the other day, can you speak a few words about Professor Venkataraman garu before you go into the subject?
Thank you. First of all, I am so grateful for the invitation to pay my respects and homage to a great professor and a great jurist and a great scholar, Professor S. Venkataraman. Mine is a very humble attempt at recollecting some of the important aspects of international law through which we have passed through during my long journey. It is true, if you count my first day on which I was exposed to international law by Professor P.S. Murthy in 1961, 60-61 as a part of the BL class. 2021, I completed 60 years doing nothing but reading and struggling and trying to understand the substance of international law, its application to day-to-day problems that we have been facing as a nation, as a people, as citizens of the world. But how does anyone in 60s with no particular understanding of what the world is at that time, except that I will quickly tell you a couple of things, but unfortunately, my problem is if I start talking, there is no end to it. And you have a limited time. And one of the things that happened was I was a student of mathematics in BA. And incidentally, Professor Murthy was also a student of mathematics, if I'm not mistaken, if I recollect. And but I never got more than 50% or 45% in mathematics in the BA. I applied for MA because first of all, most of us who grew up in the 50s were looking for science and mathematics and medicine as entry points for all people with high IQ. If you don't get into those subjects, you are not considered to be an intelligent student. So BSc, mathematics, medicine, these are the goals for which all young people were being pushed those days. Law is the last priority. And if you don't get admission into any of these higher learning in mathematics, medicine, etc., then you try to come to law college because you have nowhere else to go. And so it's like a last refuge. And in my case also, it became a last refuge up to a point. Not really so. It happens to be, as life turns out to be differently. I realized it was my first refuge, not last refuge, but it looked like a last refuge because I could not get admission into MSc Mathematics, which I wanted to do. And I went to Harvard University to get an admission there, which they were ready to do because there were no students for them also at that time in MSc. So they were ready to take me. But the professor who was sitting there to ask me, who came from Guntur at that time, and he said, look, Mr. S. Rao, I've seen your marks in mathematics. You never get more than 45%. And why are you after mathematics? After all, mathematics is not after you. Why do you want to come and study mathematics here? I have a seat here, I can give you. But why do you want to do this? You are not getting more than 45, and in mathematics, unless you get 90, you are not a student of mathematics. So I told him, sir, my brother is a mathematics. My father and others have become lawyers already. 3 lawyers are in the family. And but then I thought I should pursue mathematics because this is one career which will be useful to the country, because almost everybody is doing that these days. But I did not get it because I was playing volleyball instead of going to attend the classes in the mathematics in the afternoons. As short as I am, I was representing the state, university, and all that in my career in volleyball. So give me a chance. Maybe I'll try to do 1 semester, and then if I don't succeed, then you throw me out. Then he said, no. That is not the way to do it. You go home, try to see if you can get into law college. And because your family comes from law background, you're speaking reasonably well and you're honest about your limitations and you are motivated, I know that. But go back, try see if you can get into law. So when I came back home, my father immediately sent me to Andhra University with another brother of mine who studied, second brother of mine who studied already under Venkataraman. So we went to Venkataraman, and now the Venkataraman comes in. Venkataraman as a professor, during the daytime is extremely formal. He is this famous turban worn by Radhakrishnan and most lawyers those days. And he is extremely formal in the school and very strict disciplinarian. Even the law teachers who are working at that time in the Andhra University, like B.S. Murthy, general never used to sit with him. But Guptesh, Ramchandra Rao, and Shastri Garu and others, they're all used to sit around him, And he used to, I don't know what he used to tell them, but whenever they have time not teaching, they're sitting around him. And students can walk in only for a purpose. And when you go there, it is disposed of in 2 minutes. But then in the evening, when he goes home, he puts his lungi and just a banyan and a towel on him, and no turban, completely bald head and gray hair. And he's sitting in a small garden, which is not even a very big one, though. Andhra University gardens, the teachers had those days, very small ones. But in the small garden, he will sit there with a chair, and anybody can come and talk to him on anything. And that's when you go and pay, not only chit-chatting with him up to a point, because his old students, alumni used to come and chit-chat with him, but seek a lot of advice from him also. They used to bring all kinds of things. And then they used to be, if I'm coming from Guntur, I had to bring some, always everybody has to bring some fruit, some this, that, and give it to him. And he is happy. In the evening, he is completely different human being. He is enjoying the company. And then he's giving all the best advice possible. So in a given evening like that, my brother takes me there and says, sir, my younger brother wants to study law. And we came, in fact, already, yeah, just about to start, session about to start actually. Admissions are over. So he said, you know, then he looked at me, how old are you? I was just 17, you see. And he said, my God, your two brothers came to us at little older, but then you came much younger. And I would certainly be happy to take you in as a law student because your brother brought you and you said you want to study and you're looking young to me to be able to do something. But you have to promise to yourself, he said. Law is not simply a subject you take because you did not get any other subject to study higher. Two, it's not a subject to just study to go to do a government examination, service commission examination, and get into government and go and stand under a tree in a local town where you don't have any cases. Law is something that has a purpose to serve, and there are people who need it to serve this community. It's social justice. All these things are important, and I think if you promise to me that you will make law as a career, as a social service, as something that will put you not just to waste your time to just become another government babu here or there, I would take you, he said. So right there, you can see Venkataraman motivating you. The first teacher in Dharwad is the one who recognized my aptitude in few minutes of talking and pushed me out of the mathematics. The second teacher is Venkataraman, who already tried to set a goal for me even before I joined the bloody law school. And then we joined. I mean, you have no choice to say, yeah, we don't even know what he's talking about, so we joined. Then the first day he comes to the class and gives a lecture. And what does he say? He says, there is a ego. He says that most of you I know have joined this law school for lack of any other opportunity into any other subject of your choice. You thought it is a privilege to join, but you came here because you have nowhere else to go. And I know that, and you know it. However, let me tell you, people come to law without knowing why they are coming. But once they come here and apply their mind, they know where they are going. And in fact, they will go to a long place, many places and long distances. And he said, you know, in Germany, other countries, refugees went to London. And for example, people who never studied law, even at the late age of 66, 65, they have nothing else to do. And they couldn't find any place in what to do. They also joined law and became Queen's Counsels and made extraordinary contributions to the societies. So you can join law at any age. You can join law with no particular interest in it in the beginning. But once you get in, if you apply your mind, you're serious, law is the best thing you can ever find as a means to serve not only your own immediate means of family needs, but also community in your own humble way. This is what he said in the first day. And so true. Then he started teaching us contracts in the first year. Even today, the 5-6 principles he tells us in that class are the fundamentals. You can never forget them. For example, if I sell you, you will understand. What is a contract, he said? An offer, an acceptance, and there must be consideration. Then only it's contract. And now you can write books about these three aspects in contracts under current systems also. Just 3 sentences, 3 words. When it came to Hindu law, most of the Hindu law was law of succession. But then he tried to put it in the broader context of Hindu dharma, this, that, and everything else. And the very interesting methodology of his teaching is different. He used to write to All India Reports, Madras Law Journal, many other things, even as he's sitting here. In the class, he comes, these two fingers, there is a strip. I don't know how he cuts it maybe he cuts it in the office. He writes what he wants to say, the case law and the particular thing, he puts them there. But you can see it as a student sitting on the other side. He will keep it in his fingers. Once in a while, he will look like that. And then he will go to the next subject. So the entire class lecture, he used to organize himself in a strip and put and cover it within two fingers. Anyway, this is the methodology. But then once he starts going, there is the flow with which he presents it. And 40 minutes or 60 minutes and 45 minutes in the class. So 20-25 minutes will just go like that by a very, very quick oration and then 20 minutes he gives a dictation. I don't know you people are what your people are doing these days in the class, because those days we have no textbooks. We have no material to read before we come to the class and then come and ask questions like we did at Yale. Yale, they don't teach. The pity in this so-called great schools is they don't teach. The teacher is actually trying to get ideas from you by asking all kinds of questions, and you give a lot of reading for you in the overnight before you come to class. And the whole night until 2 o'clock you read in the library, and then come to the 7:30 class, and then you're dozing there in the Yale Law School. And the teacher is constantly asking questions. I've been never telling us any answers and not even telling us why he's asking questions. So we used to be, but here our teachers used to be 25 minutes lecture, 20 minutes notes. And that's the only notes we have for going to class, examinations. And Venkataraman used to do exactly the same thing and all most other things. Only P.S. Murthy never gave never gave a notes. He followed the so-called Yale method. He used to ask questions all the time. Of course, he used to teach for a while and then ask questions. Anyway, Murthy is a different story altogether. So then Venkataraman, first year I played volleyball. I became a captain. I took Andhra University team to finals, which never happened for a long time. Then I got selected as a team member of the university to go to Nagpur to play for the inter-university. And I came back. And I went and saw him. Because every time you go out, you have to tell him, sir, I'm going to Nagpur, sir, I'm coming back. And when I come back, sir, I'm coming to Nagpur. Sir, today I came, sir. He looked at me and said, "Anta bagundandi, మీరు పోతున్నారు ఆడుతున్నారు చేస్తున్నారు నాకు వచ్చినప్పుడు నేను వచ్చినప్పుడు మీ దగ్గరికి నా దగ్గరికి వచ్చినప్పుడు మీరు లా చదువుకుంటాను నేను బాగా ఎంఎల్ చేస్తాను దానికి మా సెకండ్ క్లాస్ తెచ్చుకోవడానికి ట్రై చేస్తాను మినిమం అని అప్పుడు నాకు ఏదో ప్రామిస్ చేస్తున్నారే ఇట్లా టైం బాగు చేసి క్లాస్కి రాకుండా మీరు ఆడుకుంటే ఎక్కడికి పోతారు మీరు అని అడిగాడు. దెన్ ఐ సెడ్ సార్ థ్యాంక్ యూ వెరీ మచ్. University also demanded a little bit of my time on that, but from now on, I will not play competitive games. I will only play in the evening and attend all the classes. So there are afterwards, I took it very seriously and started studying. And there, in other words, 1960 is the beginning of a transformation in my life from a playful, otherwise kind of a mischievous young man into somebody who wants to understand why I am doing law. And I tried. And even today I'm trying to do that. So believe me, the 60-year journey has never really taught me anything except everything you have to do it fresh. And I tell Sumitra, and I'm telling you, if you go into the ladies particularly understand this, you go into the kitchen, you prepare a food for the day. You have done it all your life now. Wife, children, grandmother, and children. But still, if you go into the kitchen and to prepare the same tomato chutney or same sambar, you put in the same effort as you put in the first day. You have to cut the same thing at the tables. You have to go through the same the pain of choosing the right the modules of sugar and salt. In the same way, when you prepare a note for any particular purpose, no matter how many times you may have done that thing before, it is still the same old first date problem. You have to go through it again and again and again and suffer the whole process of creation. And that is the essence of scholarship. So scholarship is something, it's not given. Scholarship is something. You have some disturbance? You are able to hear me?
We can hear you, sir. Please continue. Please
Okay. So because there was some noise coming. Anyway, I will now close this chapter that Venkataraman's motivation was only followed up by later by P.S. Murthy and of course Professor McDougall at Yale, and all of these teachers have made what you are today. And in fact, when I became member of the International Law Commission, both Murthy and Professor Murthy and McDougall particularly wrote notes to me, and particularly McDougall told me that, Rao, I'm so happy that you became a member of the commission and a legal advisor of Government of India for some time now. And you have fulfilled the dreams which I and Murthy had to do these things. And I wished Murthy do it, and I wish I had a chance to do them myself, but you have done it. And in you, we see our dreams realized. And I felt extremely humble. Anyway, now coming to this today's topic, let's get on to the topic a little bit, because this itself is a very complicated subject, and time is short. And I have struggled, as Sumitra said, to put together some ideas. There are two ways to do this. One is to read it, but that may take, it's about I will call them as essentially my notes, but this is still a very, very rough draft. And what I'll do is I'll keep reading it a little bit here and there, but then I will try to summarize and then try to reduce the length in which time that it takes to get through the whole thing. And let's hope that we will finish it sooner than I hope to do it. In this lecture, I will try to first identify some elements of rule of law and follow through a review of the structure and substance of the same in terms of how international law has been developing, highlighting significant aspects of them, because international law is the basis of contemporary world order, has been so since 1945, more so since 1945, and has acquired such fundamental significance in terms of projecting values and systems that not only will give us a better life, but also to ensure that life is not threatened by the current dangers and otherwise so many other problems, that challenges that the community of humanity is facing. So therefore, the rule of law, there are a few things which I must quickly dispose of. First of all, international law is a system that, whether states like it or not, work with it, and people, in spite of their disappointments, know it is the only means by which they can still seek remedies for the problems they face daily. And this happens both at the national level in human rights, just Vice Chancellor had spoken. Almost all human rights activists use international law as the basis on which they demand certain respect for rule of law, even from those who flaunt them regularly. So therefore, rule of international law and rule of law is a reality, is a fact by which even those who denounce it pronounce justifications in its name, and those who are denied seek justice by using it. So therefore, we will not waste time to consider whether it's a vanishing point of law or not, which Bentham and others have said in those days. And that's no longer a matter for, even by 60s, when we were doing international law, we were not wasting time on those matters. Two, when we look at many issues that are facing the world, there are all kinds of theories why we are facing these problems, and theories about international law and theories about world order in what you call realist schools, who believe that, like, the famous realist schools are those who in real politics, like Markanthau and many others, have thought that law is nothing. I mean, politics is nothing but power, and therefore balance of power was the system by which you try to manage your life and try to get one ahead of the other by various means to gain power and then impose it on others. I mean, that was the I mean, it was not wrong for them to have felt that is the only way, because that was the way empires were built. That was the way Europe has decentralized itself into nations, from empire to nation, as Emerson has said. That is the way the Chinese kingdoms, Indian kingdoms, and then Mongolian kingdoms, and God knows how many kingdoms came and gone, and all of them practiced most of the time in international relations certain amount of power politics and balance of power. And Southeast Asia, you cannot believe how much balance of power was the issue there, with Japan hitting left and right at other countries as a power by it. But Japan itself was hit by Russia and Western powers going all the way in terms of colonialism, and Japan was a victim of unequal treatment itself. So given all that, balance of power as the main source of international relations underpinning the world order was not uncommon and not unexpected. But then Dharma in India, for example, Dharma Sutras, Vedic scriptures, king is the incarnation of God, and nobody is above law, including king himself. And these are the concepts which are simultaneously also coming and then simultaneously taking root. After all, in Europe also, you have seen Pope and the state and the church situation existed, with church commanding loyalty from state for a long time. The story of Becket, which we know, was full of that conflict between state and church, and how Magna Carta and other things later came and established more formally the rule of law. The rule of law as a concept was, first of all, nothing new in terms of what I'm telling you, but then the word was coined first time way back when just getting to my text here a little bit, give you the clear picture. Okay, in the United Kingdom in Europe, which influenced the contemporary conceptions of democracy and rule of law, at least in common law countries like India, the importance of rule of law was noted in 1866, and supremacy of law was emphasized as early as 1867. Dicey spread the notion of rule of law at large through his work, An Introduction to the Study of the Law of the Constitution, in 1885. Other countries and indeed regions of the world have evolved their own versions of rule of law and conceptions about supremacy of law. So with respect to international rule of law based on international onuma, the celebrated scholar from Japan observed, what most international lawyers have called international law to the 16th to 18th century was just one of many normative systems which existed in various regions of the world. A comprehensive and universally accepted definition of rule of law is therefore not, but incidentally, even today, not every government in the world works under a constitution, written or unwritten, with a parliament adopting laws, an executive in charge of governance in accordance with the law of the land, and an impartial and independent judiciary to apply and interpret law with competence to engage in judicial review of legislation as separate but equal branches of the same. Many countries don't have these same systems. That therefore, a universally accepted definition of rule of law is therefore neither feasible nor essential. Broadly speaking, the essential purpose of democratic form of government is to promote the rule of law through, though in reality, no one form of government without a culture of compliance. I underline the word culture of compliance as central to entire rule of law, could guarantee the same and can claim exclusive credentials to sustain and support it. Transfer of power through ballot bags or elections conducted on the principle of universal adult suffrage is yet to become a universal phenomenon. Only began to be practiced in the United States since 1920 and UK in 1928. This is interesting. US is practicing this before UK. Palace coups or revolutions still operate in some parts of the world, with Orange Revolution and Arab Spring providing some well-known examples for change of regimes and governments. Against this background, it is easy to appreciate the role of international law in the evolution of international rule of law in the contemporary world. Now, law is a product of social process and regulates the same. Social process involves, as Laswell and McDougall explained, a continuing flow of interaction in which people strive to maximize values, employing institutions affecting resources. Law, in other words, is a system that is evolved by the members of an independent, interdependent, and constantly interacting community composed of principles founded in their common interest to regulate the activities of its members in pursuit of their interests or values. International law is equally a product of world social process and regulates the activities of participants in a globalized world that is interdependent. As such, international law is as much a system of law as national law at the national level. As Shabtai Rosen, a celebrated authority of international law, noted that international law is an independent and self-standing branch of law and of jurisprudence, of legal science and legal philosophy, but it cannot be and must not be separated from law as a whole. Further, international and national law are closely related to each other and are mutually interdependent in a globalized and integrated world order, widening the scope and impact of each other in their respective spheres of operation. International law plays an increasingly dominant role in dealing with such fundamental aspects of domestic law as human rights, environmental law, criminal law, protection of investments, intellectual property, exercise of domestic jurisdiction, and regulation of extraterritorial jurisdiction, treatment of aliens, due process of law, and more broadly, in the interpretation and application of principles of constitutional law, which is regarded as a living tree. International law and domestic law are so intertwined at so many levels across a wide gamut of their operation substantively and procedurally that it is obvious, as Judge Bingham, a former Lord Justice of the UK, well observed, that rule of law cannot plausibly be regarded as applicable on one plane and but not on the other. Study and practice of international law, and therefore it is important to note that a good grounding in national law is essential to better appreciate and study and practice international law and vice versa. Now, having said that, I want to bring out certain fundamental differences between the two disciplines and why each one requires a lifetime engagement, and one cannot substitute one's experience in one area to become somebody in the other without putting time in the other also. Why? In the sources are different. The sources of international law are treaty and custom, which in turn are based on the practice of states, which in turn is determined by the national interest as they see fit by the nations at a particular moment in a given case. So this, whereas in the case of, and then law and judicial settlement of disputes is essentially by consent only. And if you take these principles, you can see how distinct and different the whole process of international law is, both in creation and its application, when you see what the national law systems like in India and other democratic countries we see happen. You have a parliament giving legislation, you have an executive supposed to be enforcing them on a day-to-day basis, and in case of problems, we have a right to go to the court to get the advice and determination of what the law is in a binding manner by the judicial system. System is completely different. So if you work and become a great constitutional lawyer and a great practitioner in national law, it does not help you to come and become somebody in the international system unless you work with the national interests, the political dynamics, the historical context, and the given parameters of a particular case, not only in terms of the legal principles applicable, but in terms of their viability and application in the given situations. To tell you the interesting point, Judge Jennings used to say way back in one context, Judge Jennings of great professor of Cambridge, along with Harsh Lauterpacht of those days, and then later became president of the International Court of Justice also, and one who trained Brownlee and others also as students. He was a teacher to all of them. He said there are some cases in real life of international law that are best left to political process than attempting to find quick fixes in terms of law, because there won't be durable solutions. So you need a certain transformations and a preparation of the ground before some of these things can really be properly be taking their own role and course in terms of settling matters. So therefore, certain things will take time, and that is natural in the process because of the very ground around which this whole system develops. Now, having said there is a tremendous amount of difference between the two branches of law, which are both branches of law and both interact, both are mutually dependent, and one should be well versed as far as possible in both systems to be good in any one of them, but one cannot substitute the other. A mistake that is being made in many quarters, that's why I mentioned this point, which is has to be borne in mind. Now, coming to the basic sources of international law, which are again a matter of importance to understand how rule of law works out. See, for both of them, state practice is very essential. In other words, treaties are concluded by states to solve some real issues through negotiation and accommodation of interests. Therefore, there is a certain accommodation and mutual goodwill and reciprocity that is built into treaties, and therefore, treaties concluded have to be honored with a pacta sunt servanda is a pacta sunt servanda is a ancient wisdom which underlies the implementation and incorporation of treaties. There are hundreds and thousands of treaties these days. In terms of customary international law, which is even predates treaty making, and in the earlier days in 16th century and other days, is customary law that is dominant and treaties are exception. But now treaties are the dominant one and custom is utilized only as a matter of interpretation of these treaties, and essentially they, because of progressive development and codification of international and progressive development that has taken place since United Nations, treaties have become dominant features. And customary law, of course, is very important. Both interact with each other enormously. And here, the customary law, as I said, is important, and much of the modern law of the sea has been a product of customary law. The freedom of the high seas has had a long history of evolution since 16th century. It regulated the operation of warships, the right of innocent passage, flag state jurisdiction, fishing, and overflights, except for the territorial sea over which the coastal state was given and continues to enjoy sovereignty under law. The law of diplomatic relations and the law of war equally had their roots and branches in customary international law. The two sources interact, that is treaties and customary law, interact in more ways than one, supplementing and consolidating as well as interpretation as well as in interpretation or application of the relevant legal rights and obligations. As the ICJ found in the armed activities case in 1986, the fact that customary principles of international law recognized as such have been codified or embodied in mutual convention does not mean that they cease to exist to apply as principles of customary law, even as regards countries that are parties to such convention. This statement I will explain a little bit, because this will, I mean, I'm departing from my own prepared statement to give you a depth into statements like that, because when you read them quickly, you heard something, but you really don't get it. What this statement is saying here is, the court is saying here is, first of all, customary law has developed. Later, states have taken some of this principle and put them in a treaty. They have codified it and slightly changed it here and there, concluded a treaty. So this principle, which is otherwise customary law, now came into the treaty. Does it mean that customary law finished and is no longer relevant, and then we'll only look at the treaty when a problem comes? Or does it survive? Customary law also survives, not only for those who don't become parties to the treaty, but also even for the parties to the treaty, can they still rely upon the customary principle, even if it is otherwise embedded into a treaty to which they are parties? It's a very interesting, complicated issue. And why it's interesting and complicated issue, this is why I want to break away from my statement and explain to you. In the Nicaragua case, this became very important principle. What happened was, Nicaragua was complaining. Of course, I will discuss that little later also again. But in the Nicaragua case, a small country was fighting a big country like United States, which was interfering in that region and trying to create issues which Nicaraguan government at the time find it as interference and use of force against them, because it was aiding and abetting the rebels against then current regime of Nicaragua. So they did not know how to handle this thing, and power politics wise, they have no way to really question what's happening there. And Colombia and others are all, Latin America is lined up against them, and America is dominating. And then the world is not taking much interest in this kind of small country problem against a big country in their own backyard, as it were, Latin America, and sphere of influence, we would call it. And so how do you handle this? They went to Professor Brownlee and others in Oxford to see if they can do something about it. And then they said they will file a case against them in the International Court of Justice, because use of force is prohibited under the Charter, and it's a violation of UN Charter, and use of force is prohibited under international law, otherwise also under customary law. So we'll go to the court and complain that they are interfering in, because United Nations Charter is based upon two basic principles: prohibition of use of force under Article 2.4 and non-intervention, and under 2. So when they filed the case, one of the problems that came up was, if you file a case on that UN Charter principle, the other members of the United Nations also should be parties to because it's an interpretation of that particular principle under the Charter that is involved. Other members of the parties also, United Nations also have to be impleaded for this particular case. And that becomes a big issue, because this is a bilateral dispute and they don't want it to make it look like a multilateral dispute before the court. So the parties have to be, cannot be impleaded like that. So then they say, if you can't use UN Charter as the basis for this thing, where do we go? Then they said, after all, customary international law prohibits use of force. So why not we simply use that, not Charter, as a basis for this particular treaty? Because if you the Charter is after all a treaty, even though it is much more than a treaty in terms of what it does and what it is meant to be, and it's a constitution of the world. But then, if you go to this court and ask for a particular relief, under a treaty provision, as it were, you would have to implead more than the United States into this case, and which they found it impossible to do, because jurisdiction does not lie with many countries who have not given the consent to the jurisdiction of the International Court of Justice, which, as I said, was one of the fundamental principles of rule of law in international law. So how do you bring in the states which did not consent? And without bringing them, how can you go under the particular treaty to deal with this matter as a principle of the particular treaty affecting one of the parties by another party? So then the question arose, and thanks to this particular decision also, it was clear that it could be done if by pleading the case of Nicaragua as a customary principle of international law. And they succeeded. Can you imagine when the court found under Justice Nagendra Singh's great leadership, when they, which is again a very important contribution that India made through Nagendra Singh to that particular matter, and which has since become the very, very important principle in almost all use of force cases these days. And when they succeeded, the United States withdrew from that particular case, saying that they will not further participate because the jurisdictional clauses the court found was valid in their case. They found it not suitable to their liking. They did not like it. So the case went on ex parte thereafter on merits. Then later the United States also denied the decline to honor the judgment. That's a different story altogether. But the important point here is the customary law principles survive and stay and available to the parties for pleading their cases, even though they are incorporated in a treaty, and the treaty itself is otherwise binding on the parties between the two of them. And if they cannot use that treaty, customary law does come into play. So in other words, even after incorporation, it has a life of its own and can be used as an instrument. That is the point this particular case is once again emphasizing, and that I think is a very important point in rule of law, understanding of rule of law. Now, already explained quickly certain concepts of treaties, customs, how they interact, and some of these things. And I think when we come to publish the lecture, you will have more details in that. But another aspect of international law, which has become even more extraordinarily important, but people don't seem to realize the importance of it these days, is the principle of right of self-determination and the principle of jus cogens. First of all, the principle of jus cogens was brought into the picture under Article 53 of the 1969 Vienna Convention on Law Treaties, which was negotiated great effort after the newly independent countries have come into play following the end of colonialism. But colonialism was concluded, was terminated, was stopped following 1945's establishment of the United Nations and recognition of equal rights and self-determination as one of the pillars of the purposes and principles of the United Nations. And colonialism, it lasted for more than 200, 400 years, and how many countries in the world were under the spell of that particular regime, losing their sovereignty, independence, territorial integrity and political independence. Countries like China, India, and big countries, and Brazil, and all of those. Of course, the Latin American countries don't come under colonial problem. That's a different issues they faced because the early discoveries, and then Spanish and Portuguese colonies, they got their independences differently. But the Asian African countries have to emerge out of this colonialism thanks to this self-determination principle. And India's role in this is extraordinary, not ordinary, extraordinary. And not only it got its independence, but it was the pillar around which the independent movements of other countries were organized. And self-determination is the point. But then, to bring in self-determination as a principle of jus cogens. First of all, what is jus cogens? This was a question that was asked when it was first raised as a principle by Waldock as a rapporteur on law treaties in the Law Commission. He is the first person, British jurist. Incidentally, Britain never accepted those days the principle of jus cogens at all. In fact, the professors and others from that country said, question, what is jus cogens? Jus cogens is a Latin term and has no particular meaning in terms of how to interpret what its content and how it would apply to the current situation of international law, which is based on consent. And then jus cogens means what, first of all? Jus cogens is there are certain principles of a higher order that have been that emerge in the system of international law, rule of law, which once they emerge, nobody can contract themselves through treaties or otherwise practice which is in derogation of those higher principles. In other words, certain principles emanate to a level of hierarchy that anything else you do has to subordinate itself to the hierarchy, and you cannot create rules and regulations which are contrary to the hierarchical principle. It looks very strange, but it's not very strange. As Vice Chancellor has rightly pointed out, one of the early statements today we heard also. Dharma, for example, in India is like that. Vedas, Dharma Sutras, Manu Shastras, all these things are jus cogens for many years until we change them through our own constitutional processes. And it's even today, we know what role they are playing. So therefore, those are kinds of things that society has to live by, and you cannot really contract or otherwise legislate or otherwise create a system of behavior regulated as a matter of law if it is in derogation of that particular higher norms. How these higher norms get to be created? What is their content is always a problem. Therefore, but then the concept is ancient. If this is so in India like Dharma, in Europe, as I was telling you, the Pope is the one who set the standards for a long time in the name of the higher orders of the Christendom. And then natural law. For example, all of us have understood and studied when we studied law. There is a natural law, there is a historical school of law, there is a policy-oriented school of law, there is a there are positive school of law. All kinds of schools of law are there explaining theories of law, you see. And natural law dominated for a long time. And what is natural law? Because it's God-given law. It is the only way human beings are supposed to live. And if that is the case, you have to create everything within that small, whatever that ordains you to do. That is jus cogens. Okay, if that is jus cogens, and we want to now translate that into the present system of treaty law, because this problem came up when they're codifying treaty law. So the question arose, two things. By that time, already the independence has come and many developing countries are already participating in the political process. And most of the developing countries said that the treaties concluded by my political masters in the colonial regime, we are not going to accept it because they were against us and they were against our will, not only against our will, but created essentially to impose treaties on us against our by use of force. This is called unequal treaties. So we will not accept international law that has come from the colonial origins and with the interests of only the one group of states from Europe dominating and subordinating the interest of others. And even today, we have a third world group of thinkers who strongly believe that entire international law lacks legitimacy because its origins and its foundations, its application, its orientation is still serving that colonial tendencies which were embedded into the very interstices of these processes of law. And so that's one school which is very dominant actually amongst the younger group, I would say. And I don't have time to really deal with that aspect in a short lecture like this. But then this is going to tell you why jus cogens is so important. So what happened was self-determination has been accepted. Apartheid is going on in South Africa. And if you want to, and then as you know, even after this in Rhodesia, there was the white supremacists were ruling at that time. And if you want to really get them off the system and tell them that what you are doing is wrong, you need to have treaties are there, and then the United Kingdom is entering into treaties with these guys to give them the kind of support that they needed to went ahead as part of the old colonial collaboration. So therefore, India, Dr. Krishna Rao, and then of course Krishna Menon, and of course Nehru, and all these people whose names we don't talk about these days because they are too long and they're embedded in history, and then there are new trends have come up. So we don't go into that now. But then these are the people who are motivated by a system of projecting self-determination and as the basic principle of to end colonialism and to rid international law of its colonial foundations, and therefore they were trying to fight the very certain principles and certain treaties. So when you are codifying law of treaties, one question arose: does the law that we are now that existed before has no role to play in terms of when it comes to question of dealing with newly developed countries, newly independent countries? And in other words, do they have a duty to honor a system of law when they are joining a particular world order? To what extent are they bound by existing rules? That is the question. So how do you explain that to a group of young people who are coming to these conferences to accept that certain treaties concluded must be honored, that pacta sunt servanda principle, unless you project at least some points as higher norms, and therefore use cogence was one of the means by which to suggest that you can do many things, but you cannot do all the things that you want, because there are certain things we all have to accept if we are going to live in one society as collaborators and as members of the community. So that's the point use cogence was trying to say, and that's why Waldock brought that thing into it. However, initially UK itself was opposing it, because the point the third world countries took at that time was, all right, if we say that there are certain higher norms, let us say racial discrimination is something that is a higher norm, you cannot apartheid must go. And if you say colonialism is bad, we should say right of self-determination in terms of eradicating colonialism is a fundamental principle, and you cannot anymore engage in that thing because it's a higher norm. So in order to project them, these people said, all right, we'll accept use cogence. Once these people accept for the reasons they're accepting, UK said no. So under the circumstances, the content and the purpose and the limits within which use cogence have to be developed became a big issue. But nevertheless, it shows, thanks to the efforts of India and others, the use cogence principle was incorporated. But then the developed countries have said at that time that if you accept use cogence, on the content we have difficulties. So whenever there is a dispute that involves a use cogence principle, it must be compulsorily, it must be put to compulsory settlement of disputes through the International Court of Justice. India, for example, did not sign Vienna Convention on Law treaties because of that particular compulsion, which had to be accepted as a principle under the treaty. That is, if any dispute arises in terms of use cogence, it will go to the International Court of Justice. So we never became party to it, even though we argued for use cogence, but we don't want it to be delegated to a group of people coming from different regions, not sharing the same concept of what the use cogence is all about. Under the circumstances, law of treaties incorporated host of customary principles, and we have cited and quoted law of treaties in many, many instances. Therefore, not becoming a party to the treaty itself does not mean that we don't accept all the other principles, only the settlement of disputes. Similar thing happens in some other cases. When we signed the Political and Civil Rights Convention, we put a reservation saying that self-determination, which is one of the principles there, applies only as far as colonial situation, domination, eradication of colonialism is concerned, not otherwise. Some of these matters have been accepted as use cogence, and then self-determination is one of them. But there are some uncontroversial principles which have been regarded as higher norms as part of use cogence. That is prohibition of use of force. Then the slavery, piracy, and genocide. These are all considered to be higher norms and as part of some candidates of use cogence. In fact, Brownlee and others have accepted in their long essays of scholarship, they have projected use cogence as a very important and fundamental principle which everybody accepts. But only question is, there is the point he makes is there is less authority, there is more authority for the concept and not so much for the content and what it means in a given case. So that is the way in which use cogence and self-determination really works out. And then, having explained the background to self-determination in terms of what it is and use cogence also, there is another concept that came simultaneously that is called obligations erga omnes. Incidentally, why are we talking of self-determination in terms of rule of law, lecture on rule of law? Because rule of law cannot exist but without a society of its own. Rule of law is a product of a society. Do we have a society in international law, a society like we have a national society? That is the reason why use cogence is important, because use cogence is assumes and applies in the name of the international community as a whole. The word whole is very important. So if in 1969, in an archetypical bilateral context like regulating bilateral context like treaties, if use cogence is included, you are already recognizing we as members of the international community are entitled to conclude treaties as that fits our interest and mutual accommodation in terms of mutual accommodation. But then all these things are subordinate to something that we as an international community as a whole consider as important and higher and non-derogable. Therefore, anybody who says, by pointing out to so many problems that are existing today, as we have Vice Chancellor rightly pointed out also, can we say there is no international community? Can we say there is no law really happening because it's violated in so many places? And common sense tells us no. Problems occur in day life, in national society, in every day when you go into the town, you see so many problems happening. Murders and this and that, pandemic, how many problems are happening, we all know. But none of us say there's no law. We say law is not being applied. We say law should be applied. We say law says this. We don't say there is no law, because none of us agree and can see going back to law of the jungle. Violation of law only highlights the importance of law, you see. That's the point. And therefore, what do third world countries, small countries, and poor man in a country like India or anywhere else, what does he have to stand by except law? You tell him there is no law. It is true, it's not working for you at the moment. But if you deny it, you are even worse than what it is. Therefore, the conclusion from non-application or disrespect for law is not that law does not exist, but it's not being applied and it's not being followed, and it has to be pursued and it has to persistently be pressed. That is the message. Okay, having done that, and here comes the erga omnes obligations, importance of erga omnes. In other words, two people are getting hurt. One person is hurting the other, and he's hurting him in a manner, in a particular area, which is of so importance to the rest of us, we cannot keep quiet. We have to say something about it. We have to get involved in it. We have to ensure that justice is done to them. For example, it's a small child in Delhi, for example, yesterday again, a 9-year-old girl again been raped and killed. You think, why are then protests are taking place? Protests are taking place because they all believe something fundamentally wrong is taking place in terms of what we believe as needed for law, and it's not being followed and and it has to be properly implemented. So therefore, that is called when you get involved in situations where your interests are not directly affected as an individual. When you must get involved in a situation in which, even though your interest is directly not affected, but your conviction and belief and the manner in which you see yourself as a law-abiding citizen is being affronted, then you have an obligation to get involved in terms of any violation that is taking place. And when people who are not directly are required to get involved or otherwise are right to get involved to ensure that rule of law gets going and gets re-established and applied in a given case is what is called a community obligation. That's called erga omnes obligation in international law. So if you have certain fundamental principles by which the society exists, works, and otherwise has higher norm, if any one of them gets into conflict and is getting affected, violated, not only the person who is directly injured by that particular event has a right to complain and look for remedies, but also every one of us as members of society have an entitlement, have a right, entitlement to get involved to ensure that law is applied in that case. When I say entitlement and interest, legal interest and entitlement as not directly injured parties, I'm saying not that everybody should walk in like as a matter of duty, but those of us who wish to do it can do it. But in the Law Commission, again, there was a very big development and took place during our time as part of state responsibility, where we say that where a person who is directly injured by one of these fundamental, in terms of lack of recognition, lack of implementation, or otherwise in violation of a peremptory norm or a jus cogens, everybody else in the international community have an entitlement and a duty to press for its recognition and implementation. They have certain limitations. What is the limitation? You can only demand what the party actually suffered to be recompensated. You cannot demand more than what you want, more than that. In other words, if X is injured by violation of a peremptory norm or a jus cogens, Y and Z can also join X in ensuring he gets what otherwise you should get as a compensation, as a remedy, as a for that particular violation, and not more than that. You know, you can put your own demands on top of his demands, taking that as an occasion. That's not correct. So that's not allowed. That's called erga omnes obligation. Does not allow that. You have a right to involve, but only involve to the extent to which the damage requires to be remedied in terms of that particular principle, in terms of what it has affected somebody in a direct way. So that's the limitation. Second limitation is, if nothing is happening and the wrongful act continued and the damage is continuing, then you have a right to say no and not recognize the effect or consequences of those wrongful acts. That is the second principle of in terms of that arises and applies in terms of others who are not directly injured. The fellow affected does not recognize anyway the situation. He will continue to fight against it. But you as a member of the community also should not recognize and not really give any respect for the particular violation, any consequences that are arising out of that particular consequence. You know, somebody went and occupied somebody else's territory in violation of the use of force. Not only the person who suffered that territory, lost that territory, will not recognize his occupation, but others also should not recognize the occupation. That is the kind of principle that we are talking here of erga omnes obligation. But I explain these things up to a point. Why? Because if international community has to come together and has come together and is living like whether they like it or not, interdependent, interpenetrating manner in various social processes wise. We have two basic things which I have highlighted in international law. One is the termination of colonialism thanks to self-determination, which has brought a completely different order altogether since 1945. And two, treating that as a higher norm as far as the eradication of colonialism is one aspect. And the other aspect is that government's obligations that exist, whereby everybody should, not only those who are affected by these principles, but also those in the international community must also recognize the as unlawful such consequences. So this is the rule of law. This is the new concept. Since 1945, this has become. These are the two: prohibition of use of force and self-determination first, and prohibition of use of force are becoming the greatest fundamental principles of rule of law in international order. Now, I will try to jump a number of cases which have come together. First of all, before I get through them, the ergonomous obligations was first recognized by the International Court of Justice in Barcelona traction case, and that was the Barcelona traction case, and was again more recently, of course, this was also recognized in Belgium versus Senegal, also a case which is of a more recent order. First Barcelona case was in 1970, and the later one, of course, the more recent one. Then in the case of self-determination, very important two cases must be mentioned. One is the Western Sahara case involving Morocco and there is a group of persons in that particular case who are also not belonging to the Morocco, but then were under the owed certain loyalty and allegiance to the King of Morocco at one point of time. So in that case, again, the right of self-determination matters came up. Incidentally, right of self-determination evolved since 1960 much more fundamentally, and by the International Court of Justice, which recognizes these developments, confirms the validity of the principle in Western Sahara, confirms the validity of the principle of self-determination as a principle of international law. The court in that case referred to the basic principles governing decolonization. And apart from Articles 1, Paragraph 2, Article 55, 56 of the UN Charter, the subsequent development of international law in regard to non-self-governed territories as enshrined in the Charter of the United Nations, which according to the court made the principle of self-determination applicable to all of them. The General Assembly Declaration on the granting of independence to colonial countries and peoples resolution in accordance with Resolution 1514 of the 15th General Assembly proclaimed principle of self-determination as a right of peoples and its application for the purpose of bringing colonial situations to a speedy end. It noted, among others, in paragraph 6, that any attempt aimed at partial or total disruption of the national unity and the territorial integrity of a country is incompatible with the purposes and principles of the Charter of the United Nations. This is an important point that came up for a very, very serious consideration. In the latest case in 2018, the decision was given by the International Court of Justice because of a advisory opinion sought by the International Court of Justice in the case of Chagos Archipelago and Diogo Garcia Islands. And you know, Chagos Archipelago and Diego Garcia Island were part of Mauritius when they were colonized by United Kingdom. But later, in 1968, when United Kingdom was giving independence to Mauritius, it separated these colonies 1 year earlier and told them they will return them to them when the independence is being given or later, depending upon once the need for which they are separating them from these islands and including them along with a few islands taken away from Seychelles, created a new British Overseas Territory, BOIT, something like that. British overseas international territory. And they did that because United States wanted to take from United Kingdom a lease of for 99 years the particular area to establish a military base, because new colonialism colonialism having gone and lots of new African and Asian African countries have emerged. They needed a base. United Kingdom and more so United States needed a base in this area, and that's why the Britain had taken these particular islands away prior to granting independence in 68 by talking to the leaders of Mauritius, but did not really. It's got a Lancaster understandings. There are no agreements really handwritten, but then there are agreements and certain understandings which the current leadership have not really considered them as binding. And and then when they took it away, because they were, first of all, they were very eager to get some independence at least for the major part of the Mauritius. So I suppose they were under certain pressure. We will get to accept the formula as a political necessity rather than as a willing giving away of separation of this particular area. And the Chagosians who are living on these islands are few, but then they are also poor fellows. So they have no means to represent themselves in any of these talks. And later, when they were, after removing, they are separating these islands, they were removed forcibly and prevented from returning to these islands under very, very unfortunate circumstances. All these things have caused a great consternation to Mauritius when it became independent, and it has been fighting the separation of initially the Chagosian island, the Diego Garcia, and later when they were creating the military base, and when they have not returned this even after 50 years or whatever initial agreement, and then they were again renewed it with the United States. Each time the United Nations General Assembly invoked Article 9, this 1514, and said you cannot separate when you are decolonizing as a metropolitan country. You cannot separate and distinguish, detach certain parts of the territory and give independence only to one part and not the other part. So United Nations General Assembly asked in 2015 whether the decolonization process was complete in accordance with the UN Charter when Mauritius has not been given full control over all the Chagos Island in terms of their earlier decision of 1960s. And that became a matter for opportunity for the International Court of Justice. And the current judges, 15 judges, have unanimously, except one judge, basically. Actually, two judges disagreed on jurisdiction, whether they should exercise jurisdiction or not. But then one judge, ultimately, the American judge, was the one who dissented. But all 14 judges have confirmed the validity of the principle of self-determination, and also the principle that while according independence, the entire territory should be taken into consideration. And much more importantly than that, the people of the territory's wishes must be consulted, and that should be the basis by which decolonization should take place. And therefore, so these principles have been emphasized in the latest case, and I think it's worthwhile to anyone who is interested in the principle of self-determination and in the principle how that operates and how the decolonization process has to be. There are certain obligations of fundamental nature, peremptory nature that are involved in this particular matter. Has to be to appreciate that. I think this 2019 decision must be read carefully. When I read them recently, of course, I know these were happening, but for this lecture's sake, I had to go through them more carefully to understand the basic question posed by Brownlee in his one of his Brownlee's textbooks. I tell you, is another great source of not only knowledge, but it gives the beauty of Brownlee's book is it allows you to not only get a grip of what the law is up to a point, but it will not answer all the questions in your mind, but will raise more fundamental questions that you did not think about current aspects of international law on any given particular subject. For example, if you read any other text like M.N. Shah and others, you will only get a good load of what's happening here, there, what you call the descriptive analysis of international law. But when you read Brownlee, you will get lost initially, because if you don't have enough knowledge of international law, Brownlee book is the last thing you should read. But if you have some understanding of the process, and if you're still not very clear what is bringing what, and you read after that Brownlee, you will find so many interesting questions he's raising and trying to tell you, in order to answer that question, how many things of international are interconnected to come to a conclusion. So that's the beauty. So I was reading that, and then Brownlee raised two questions in respect of self-determination. All right, we all accept right of self-determination exists. We all know that it gives certain obligations in terms of a certain fundamental nature, in terms of how decolonization, other things should take place. So he says, can a country use of force against another country in the name of realizing self-determination? Use of force itself is prohibited under use of coercions. Self-determination is also, let us say, is a principle of use coercions. Can two principles be put at loggerheads? And how do you do that? Can you do that? This is the kind of question he asks. Then, national liberation movements, we know, is a big role they play. When you come to national liberation movements, first thing that comes to your mind is Palestinian. They're fighting Israel occupation of their territories. They are seeking support from outside also. It's an armed struggle. In such a case, Brownlee, after consideration of various matters, projects certain principles, certain ideas. One of them is, it is perhaps, he says, legitimate to provide support to a national liberation movement fighting a cause of right of self-determination, fighting for right of self-determination. It is equally, in his view, prohibited to lend military aid and use force and otherwise support a person or a state or a group of a state to suppress right of self-determination. In other words, right of self-determination is the point here. If it is in support of it, you can use the force. If it is against it, you should not use the force. That's prohibited. So he distinguished these two to answer the question he raised. And this, can you imagine the impact of that kind of conclusion? I don't have to elaborate on it in terms of what's happening in Palestinian cases. Then take Kashmir issue. A group of people constantly fight government of India in Kashmir in the name of self-determination. And India keeps on using force, and human rights groups keeps complaining about many things about these things. I'm not taking any position on this thing at the moment. I'm only trying to show how the principle of self-determination really works and doesn't work. And in my understanding of these two cases, Western Sahara and the various and the latest case, and the separate opinion that have been written in the case of Chago's advisory opinion, I think I recommend all my audience, those who are listening to this particular lecture and those who believe they have something to learn and something to offer, must read this to judgment very carefully. Of course, my own note will come later, I suppose, as part of publication, where you find some of the points which I have argued. Conclusion I have come to it after reading some of these things is, first of all, I did not say, I won't say this for the purpose of this lecture in a given note, but I can tell you orally that Kashmir issue is not a matter of self-determination in terms of colonialism. It's essentially a partition plan. The partition plan and its implementation and the Pakistan sending raiders using force to obstruct the process or otherwise engineer process have created problems of their own. So Pakistan has less of a credible case when it used force and otherwise continues to use force through these, we call them non-state actors and terrorists. Indian government calls them. Their legitimacy in terms of the two principles I've explained, can you use force to gain self-determination? When is it lawful and when is not lawful, I think is very important. And in an article I have published in the Indian Journal of International Law on the surgical strikes, I have come to the conclusion that the people who are involved in a particular area are not national liberation movements domestically grown. They are force being imposed, force being used from outside. And that too, either under the sponsorship or under able or willing type of concept is there in international law. And maybe the support of government to these individual groups who are operating from the territory may not be, is a question, but is not a point in dispute right now. Is not a point to be considered. The important point is the non-state actors working from the territory, getting in, interfering and then engineering a process of self-determination is not acceptable. And they are not national liberation movements in the sense in which the Palestinian Liberation Organization can be considered. I mean, these are all off-site remarks I'm making. I'm not trying to put them into my basic text here because these are matters on which people will have to think when they come to the brass tacks of this matter after examining various other matters. But how my mind is working, I'm only sharing a little bit ahead of on some of these things as a consequence of why I put some of these things in this particular lecture. Here, one important distinction is there between a non-state actor whom we consider the terrorist and a national liberation movement. What is that? Rao, S. Rao, and others have studied international humanitarian law. They know it very well. That is, a national liberation movement is one that is bears arms openly, works under command, and otherwise respects and should respect principles of humanitarian law in any engagement of armed conflict. Whereas a terrorist is not only not respecting any of these things, but is actually hitting the public places, terrorizing people by bombing, kidnapping, and other means. So the means and methods adopted and the lack of responsibility, in other words, when something happens, only after the incident takes place, somebody says, we take responsibility for this. And sometimes they don't even say that. It means nothing. And then when you caught somebody, he will not identify himself as part of any particular thing. So under the circumstances, the national liberation movement is different from these kind of groups. This is happening in Al-Shabaab in Somalia, context, or in Nigeria, happening all over the world. Of course, Al-Qaeda and others are other examples in Iraq and elsewhere in Syria. So given this, there is a fundamental distinction should be drawn between legitimate struggles for self-determination recognized and these vociferous groups which are trying to work for parallel government systems for purely private ends and not public related and for ends which are opposed to rule of law in the world itself. Therefore, there is a fundamental difference in how you see these groups and that particular concept. That's why studying the right to self-determination, understanding its importance, looking for its scope and limitations, and making sure it is it is identified and respected for what it is. As far as colonialism is concerned, as far as self-determination, right of self-determination against to speed as a process of speedy end to colonialism must be seen as part of use cogents of the higher norm. But then there are other principles of self-determination. Europe and America and world says, no, it cannot be confined only to the colonial context. After all, in Europe, President Wilson has long ago talked about self-determination, even during the process of after the First World War, when the process of creation of League of Nations, and then number of minority communities, and when you transit from empire to nation, so many Napoleon wars have created their own systems of nationalism in various other countries in Europe, and therefore self-determination is not peculiar, is not special, is not otherwise to be identified solely and only with respect to colonialism, as some people think. Therefore, it is much wider. On this, I had a big difference, just as a matter of footnote I am adding here, between me and Crawford. There was a big not a big, there was at least a clash of ideas in the Law Commission when he was proposing, as part of his peremptory norms under Article 48 system, in the state responsibility articles, when he said self-determination is a right of is a part of these causes, citing East Timor case. And I said, no, self-determination is only to the extent that it involves colonialism, it should be treated as that. Otherwise, it should not be treated as it should be, because then I said the Friendly Relation Declaration does not give the right to separate territories in the name of self-determination by minorities who feel that threatened for a particular reason, as long as the system itself provides a democratic system and a representative government, and everybody has equal rights under law. You cannot then ask for separation of state simply because in this particular case or a particular time certain violations or certain grievances can occur for minorities. The problem of minorities is separate from self-determination. The problem of minorities in a democratic country is different from other countries. The problem of so some of these things have to be carefully distinguished when we talk about self-determination as a fundamental principle of international law, which helped reorganizing the entire world order by delegitimizing and also ensuring the conclusion of colonialism as a feature of it. Even though its after effects continue to bother us, and I think some of our colleagues from the third world are right in feeling bad about it. But then, feeling bad about something that exists is different from working with it to the extent you can do it, and you have no choice. If we can live 200, 300 years under colonialism and somehow survive as human beings, are we telling us that we are unable to survive now that colonialism has been officially and legally treated as illegal? And even if its after effects are upon us, should we then say dump the whole system? Should we throw the baby out of the bathwater? That is the point I have against this third world problem. I have every sympathy for the problems they raise, but I cannot share the view that international law should be treated as the illegitimate source of functioning for legitimate scholars and practitioners. And I think Brownlee was right when he said that one of the greatest depressions and he said not depression, he used the word I think is the greatest cause for disconcerting feeling, or otherwise a feeling of low feeling, you get only because of these theories, because it looks like we are supporting and subordinating ourselves to a system which we should be fighting in the street if we accept international law. But if we don't accept international law, as I told you earlier, you have nothing to stand by, and it's the law of jungle. And even Russia and China and others who have a different view of the world order live by international law. Therefore, why not we? That's a separate issue altogether. Now, I have incidentally, I have quickly and briefly covered not only self-determination but use of force. And a state is held responsible under the Nicaragua case and later cases that it influenced, that if not only a use of force is prohibited by a country to use it against another, but it cannot support either willingly or by acquiescence others who are using its territory to mount use of force which is prohibited. And then they have to take a responsibility for that. And therefore, and then there are countries which are unable, they cannot control these groups of terrorists, like in Afghanistan and other places. That's a different problem altogether. But we can also say that the question of ability, unable and unwilling. If you're unable to control them, responsibility may not come to you, but you have to cooperate with the person who is trying to suppress this thing and get involved. This problem occurred in the case of Congo versus Uganda. Uganda was trying to intervene and hit at rebels operating against it from Congo. In an area, in mountainous area and far away from the main reaches of inner power centers of Congo, they were beyond and other reach, as well as otherwise unable to control them in one way or the other. So the International Court of Justice in that case said the responsibility cannot be placed at the disposal of Congo, but because it's unable to control these areas and these people, unable. But unwilling, Pakistan may be. Not only unwilling, even if it's not directly supporting, as India says it is supporting, maybe it is acquiescing it. It's willing. So that's responsibility. That's state responsibility. So I've now given you a quick view of some of these cases, which I will eventually try to put down in some form for the purpose of this lecture. Now I come to some other matters now, because I think we are now taken already enough time. And so I will skip these basic fundamental principles of rule of law, which is self-determination and use of force. And I have explained reasonably some of the backgrounds and some cases involved in it, and Nicaragua case, and then its impact. And then I have already mentioned about the effective control and test of effective control in the case of state responsibility. There are two principles. One is effective control on the one hand, and another is overall control concepts. How much control should you have before you get responsibility for action done by private individuals in violating use of force? Those two concepts come into place. And in the Tadic case, the problem came where the individual responsibility, not state responsibility. So therefore, overall control was enough, they said. But when it comes to the question of state responsibility in Bosnia and other cases, the International Court of Justice said, no, we need effective control, not simply Bosnia versus Serbia. We need effective control, not simply overall control, because it's state responsibility. If it's individual responsibility, overall control is enough. But if it is state responsibility, effective control. Having done that, now we are coming to, I want to now get into a very important aspect of two things I must say. That international world order now is heavily textured by the international treaties. And any number of treaties have been concluded on the basis of the work done by the International Commission. And according to the output would show that over 70 years, 23 conventions have been adopted on the basis of its drafts, and 19 of these have entered into force. Of these 19, 12 conventions have been ratified widely by states. The other 7 conventions have less than 40 states parties, but its impact on the world order is enormous. It may be noted, 1969 Vienna Convention on Law of Treaties, the 1961 Vienna Convention on Diplomatic Relations, 1963 Vienna Convention on Consular Relations, and relied upon on a daily basis by officials in foreign ministries, diplomatic and consular missions around the world, legal practitioners, etc. and national judges also. Additionally, states have adopted conventions on the basis of the Commission outputs on the law of the sea, reduction of statelessness, special missions, protection of internationally protected persons, including diplomatic agents, representation of states in the relation with international organizations of a universal character, succession of states, non-navigational use of international water courses, jurisdictional immunities of states and their property, and international criminal law, and international criminal court, of course. The Commission output has also on occasion served as an inspiration for regional agreements. The 2001 draft articles of the ILC on state responsibility and draft articles on prevention of transboundary harm from hazardous activities and 2006 draft principles on allocation of loss in case of transboundary harm deserve mention as important contributions that go to build a new legal order and an evolving legal order and rule of law in international legal system. Article 48 of the draft articles on trust responsibility is based on the idea that in case of breach of specific obligations, the collective interest of a group of states or the interest of international community as a whole, responsibility may be invoked by states which are not themselves injured. This I have already explained, so I will skip that. But the 2001 ILC draft articles on prevention and 2006 draft articles on allocation of loss are important because they are not only because for the problem of dealing with hazardous activities like Bhopal case and Chernobyl accident, etc. But these draft articles highlighted the importance of prior authorization of hazardous activities and also imposed a number of due diligence obligations. And they are based upon principles of precaution and polluter pays and good governance. And therefore, in field of environmental law, sustainable development, which in Professor Rajalakshmi had done a great work on this matter, and her book is a very important contribution, environmental law and sustainability. And these principles are constantly keep coming, not only in the specific context of nuclear reactors and many other problems that are done, but also in terms of due diligence obligations themselves, in terms of dealing with projecting both not only cyber security, which I'll come later, and also the question of climate change itself, because a number of principles that are evolving require certain responsibility and certain management to prevent problems before they emerge. And once they emerge, then the principles of compensation are also very clearly laid down in these particular articles, and are considered to be not only of importance in the context in which they were developed, but also are evolving a new sustainability and protection of environment. Having done that, now the International Court of Justice and International Law Commission, how closely they interact with each other is again a matter of observation, case after case and principle after principle. And that is why most of the judges who sit on the International Court of Justice have done a term or more than one term sometimes in the Law Commission and get grounded in the development and law before they use it and they become experts in application of law. But then I must tell you here one more very, very important aspect of having sat on the court and having been in the arbitrations myself. I must tell you the following points. The deliberations and decision making of the court, constituted and composed as it is of 15 judges with different nationalities, political, economic, and cultural backgrounds, representing different legal systems, partake the character of more of reconciling often conflicting values and policies in the interest of promoting a world order with greater leverage to engage in judicial innovation, of course with the reasonable limits of judicial caution, given the nature of development and application of international law, which is distinct, as noted above, from that of the development and application of law, which is given and predictable in a domestic legal context. Accordingly, as Brownlee, who argued a number of cases, both British Superior Court and ICJ, noted, and he says, it is justifiable to emphasize that the disputes taken before the court, that is international court, have a special character and cannot be compared to the cases in front of municipal courts. Just remember that. Thanks to the UN and its work over the years, particularly during its first 30 years, some fundamental principles governing contemporary world order have also been firmed up. As I've already mentioned, these are resolutions 1514, 1970 Declaration on Friendly Relations, and many mention may be made of the political and civil rights, social, economic and social and cultural rights, and many others. And one of the major achievements of the Third World is to get new law of the sea, hailed as the Constitution of the Oceans, adopted in 1982 after lengthy and intensive negotiations for nearly it started in 1975 and ended in 82, and thereafter also up to 1994. So you can see the kind of negotiation process that it created. In addition, international has moved towards recognizing not only the rights and obligations of states, but also responding to the needs of plurality of actors, including international organizations, individuals, corporations, and other non-state actors. Here, the non-state actors are not the terrorists I'm talking about, but the non-state actors like NGOs and many other law-abiding and law-promoting actors. Most important of all, the increasing focus of the world order and hence of international law is shifting from state-centric preoccupations to individual or human rights-centric concerns. The welfare of the common man or eradication of poverty, human dignity, protection of fundamental rights, non-discrimination, equal rights and opportunities, protection of environment have become the central themes of the current global agenda, incorporated in the 2015 Sustainable Development Goals and good governance at the national level. And the Sustainable Development Goals are the blueprint to achieve a better and more sustainable future for all. They address the global challenges we face, including poverty, inequality, climate change, environmental degradation, peace and justice, of which Vice Chancellor also spoken. According to the UN 2020 report on these goals, the progress towards achieving the targets by 2030 was uneven between 2015 and 2019, which has since the break of the COVID pandemic in 2019, I quote, abruptly disrupted implementation towards many of these SDG, that is Sustainable Development Goals, and in some cases turned back decades of progress. Science and technology made enormous progress, and during the 21st century, it raises the living standards of several millions of middle-class people. Instant communications and interaction and collaboration, research, innovation in technology and order of the day, with the promise of a better life, also came the danger of very survival of mankind with mindless and rapacious exploitation of natural resources and unsustainable use of limited and scarce resources. Limits to growth. Club of Rome was, in fact, they revealed this. You will be very happy to know that I was a young man in the Woodrow Wilson International Scholars in 1971-72 when they came to that center to unveil this particular document, Limits to Growth. Barry Kamener and others, to which Rajalakshmi writes in her book also. These are people with whom we have interacted. I had a chance to interact with them in some seminars also. Dependence on coal and fossil fuels have long been identified as a source of greenhouse gases affecting climate change. Deforestation and pollution of the rivers and seas and threat to biological diversity are the sources of concern for which no solutions are in sight, or at least no immediate solutions are in sight. Accordingly, to a recent report of the World Bank, the global economy could lose as much as $2.7 trillion a year by 2030 if countries continue to destroy biodiversity, impacting wild pollination, food from fisheries, and timber from forest. This study said that the so-called nature smart policies could spur an increase in global real gross domestic product of 50 billion to 150 billion by the end of the decade if you follow the right policies. Sustainable development and protection of environment have been a rallying cry for young and old and statesmen and scholars alike. Of course, Greta Thunberg and others we know. While the UN is focused on setting goals in this regard to be achieved by 2030, as noted above, some important steps have been taken in the field of international law. Preservation and protection of environment and goals of sustainable development is a common concern of mankind. It requires from states firm commitments, specific targets, financial base to achieve the agreed targets. The Paris Agreement of 17 December 2015 reached after years of frustrating but sustained negotiations since 1990, is hailed as a turning point in a long journey ahead. It's a legally binding international treaty on climate change. It was adopted by 196 parties at the Conference of Parties in 21st Conference of Parties in Paris on 12 December 2015, entered into force on 4th November 2016. It is in force now. And its goal is to limit global warming to well below 2, preferably to 1.5 degrees Celsius compared to pre-industrial levels. The core commitments is voluntary national commitments on the part of each country to contribute to the agreed common goal over a period of 20 years through a program of action referred to as the Intended Nationally Determined Contributions, called INDCs. And presently, many countries are working on them. In fact, China says that they're going to announce their new plans very soon. Japan has just revised them. Europe has reset itself to a higher goals, etc., etc. In connection with these things. The contributions would come in the form of planting tens of millions of trees and developing solar power to reduce emissions from coal and cutting subsidies for fossil fuels. In this case, I have just recently been going through a lot of these newspapers are full of information about what's happening on these matters. So I was trying to capture some of them also by way of ideas. For example, one commentator says global governance and climate change is emphasized in each of the meeting very recently held. Business section, according to another account, finance is crucial in the race to achieve the goals set to arrest global change by 2030. According to Global Commission on Adaptation, investing 1.8 trillion this decade in projects such as early warning systems, mangrove protection, and water management could generate $7.1 trillion in net benefits. This is the estimate given to us by none other than Michael Bloomberg. You know the Bloomberg of the United States, who's a towering figure in the financial field. Salimul Haq and Agnes Kalibata. These are people who are in charge of a commission which are working for promoting at a private level the goals of the climate change as prescribed in the Paris Agreement. The race, they say, the race to new kind of sustainable abundance, that is the article which I read recently, as recently as July 10th. And the European Union, for example, is aiming at 55% reduction of greenhouse gases by 2030 compared with 1990 levels. For this purpose, the EU is embedding environmental goals and standards for banks, money managers, insurers, and member states' public spending plans in the hope of directing trillions of euros to fund a radical revision of the regional economy. As part of this effort, the EU wants to raise as much as $250 billion or $302 billion using its first green bonds. But the EU needs as much more than that. That is 350 billions per year in additional financing to reach these legally binding goals. So when you see this, why I try to bring in some of these facts, which I was trying to read, spending time the last 4 weeks trying to gather material is, when you look at climate change and the goals it set, which are voluntary, and developing countries want a different set of goals and time limitations and self-contained limitations, given their own levels of economy, and then in the overall industrialization, they came late. Therefore, and they complain, of course, very rightly, that much of greenhouse gas emissions must be attributed to the high levels of economy reached by the developed countries, and hence they should take more active and more important role, not only in reducing these emissions from their side, but also in ensuring right technology and transfer of technology and funds to the third world countries to promote clean energy sources, etc., etc. I mean, I think this is a dialogue when it goes on. When you see this kind of a dialogue, you wonder whether there are going to be any time common. Hello. Somebody speaking?
It was just some disturbance from out.
That's okay. So am I too fast, and am I communicating anything in a manner like I'm trying?
Yes, sir, sure. And we really love the way you are putting the things across.
Okay, let me continue then quickly because we have to still do something. So therefore, given some of these urgencies, I wonder whether the kind of money that is needed, whether the kind of cooperation and consensus that is otherwise, should form the basis for rolling out some of these well-planned, scientifically observed and scientific and proposed plans to implement them, whether we are all together or not, whether we can achieve this common good of climate. In fact, today paper I was reading, it says we are no longer talking about climate change. We're talking of climate threat. Of course, one can say the threat of climate change is there. One can say a little more, put it differently. But then the levels of danger that are reaching, thanks to the forests that are burning from Turkey to Spain, and the frequent rains and floods that occurred in China and elsewhere. And in fact, the today's paper says 155%. There is more certainty that all these things can be ascribed to climate change rather than to individual and isolated events, as some people still claim. So anyway, the gravity is there, the plans are there, the proposals are there, and states have accepted this as essential. But then the manner in which they will move depends upon their own priorities, immediate priorities, and the problems they face. So we'll hope that something will come out of it, but necessary frameworks are available. All right. There are many other problems for the rule of law which is facing challenges. What is one of the biggest challenges the rule of law is facing is how many conflicts are going on. We know that use of force is officially prohibited, but the world is witnessing conflicts and conflicts and conflicts all around the places, and there are new conflicts that are looming in the horizon. If they break, they can be even more serious. South China Sea is one case. And today, for example, today's paper itself says, when talking at the Aspen Security Conference, the Singapore Prime Minister saying that America is now determined, there is a new consensus developed in America between the liberals and the extremists, that the conservatives and the progressives, so-called, whatever, liberal democrats and the conservative others, that China is an unmitigating threat and we must fight it at every stage. So this kind of a consensus, according to Singapore Prime Minister, is evolving. And he says, if you do that, you don't know what kind of an adversary you are getting into. You don't know together what you are going to do to the rest of the world in terms of its survival. So he is warning that this kind of a managing which is that in troubled waters, rather than trying to dump each other into the troubled waters by hook or crook, is going to cause more dangers, and he's afraid that more threats are looming large. And in other words, if Middle East is burning, Syria conflict is going on, Yemen never gets right, new conflict is coming up in terms of Arab Springs in Tunisia once again is exploding. And many of these things are current knowledge. So therefore, one doesn't have to say too much about it, except to say that the world is certainly endangered, not only from climate change in the long-term basis and otherwise, but also by the immediate danger of conflicts still raising all around the place. So why is this happening? The fundamental source is lack of collective security system for which the United Nations was created. Okay, collective security system is failing. Why? Because there is no Security Council is veto bound, and all the actions it takes are neither inclusive nor otherwise based on principles that owe their allegiance to the community interest rather than to private interests, national interests, or so-called national interests, that to short-term national interest. So if that is the case, what is the way out? The way out is the reform of the Security Council. And if the reform of the Security Council is what we are looking for, what is happening there? And this is a question which is very important, because here I will now, I spent last night, thanks to the alert I got from Sumitra and Rajlashmi and Rajendra Prasad and my other friends, to whom I have requested some ideas to share up to put some more meat into what I'm trying to understand myself. They said this, maybe we should explain the reform of the Security Council a little bit. So here, what I have done is looked at the latest material. In this case, a high-level panel. No, yeah. 1 second. Just give me 1 second. I'm just downloading here. Addressing the issue of reform of Security Council in an open-ended working group. No, even before that, I have to. When did it start? The reform process started quite early, actually. The proposals to reform the member security methods of working was already in place since 1994. They started, a working group has been created. 5 themes are under consideration since 2007. And these 5 themes are: size of an enlarged Security Council. What should, right now it's 15, should it be, and the demand is it should be enlarged. 2, what is the number? How many more countries should be there in Security Council? 2, categories of membership. Should we have permanent and non-permanent, and should we all have only one category? 3, question of regional representation. Should we have a regional representation in terms of like Law Commission and others have regional representation, or should we leave it differently? Questions of veto, which is linked to working methods. How do you adopt the decisions? For what kind of majorities are required for what kind of action you need to take? For recommendations, one type; for actions, another type under Chapter 7. So do we need them or not? What is the relationship between the Security Council and General Assembly, which is always very important, because even when Security Council is considering a matter on its agenda item, does it bar the General Assembly from discussing the same item as part of the General Assembly mandate? And the Article 12 is of the Charter is what is involved here. But in all these matters, there are issues, and therefore this reform process is concentrating on them. And while since 1994 and then 2007, more recently, much more focusedly. And today, where are we now? 2021, and nothing is happening. And in the meanwhile, a high-level panel of the United Nations suggested 2 models of reform, suggesting that the membership be raised from 15 to 24 and confining the veto power only to the present 5 members. That is one model. Provided for increasing the number of permanent members to 5 to 11 in this particular model. So the basic thing is 15 to 24, confine the veto only to the permanent members, and thereafter either you increase the permanent members from 5 to 11 and raising non-renewable 2-year term, that is otherwise everybody gets elected 2 years, from those seats from right now 10 to 13, allocating 2 seats to Africa, 3 to Asia, 4 to Europe, 2 to America. The second model is retaining the 5 permanent seats with veto power and provided for 8 4-year renewable seats, and allocating 2 seats each of the 4 regions and 1 2-year to non-renewable seat to the present 10 such seats. Of course, it doesn't sink into your mind when I mention this kind of thing, but I can only tell you there are numbers which are going around in this matter, and you can easily download the United Nations website to get a good grip of this matter once you get up this particular lecture, if you are still interested. Anyway, the important point to note is this: no consensus has been reached on any of these matters since 2007, and then a very peculiar procedure has been adopted in the deliberations of this informal negotiating group, which is chaired by 2 persons all the time, by appointed by the General Assembly President. That is the principle of silence. What does it mean? I got confused myself when I read it yesterday. It says any deliberations that take place within it is not recorded. No view is attributed to any particular state. So nobody knows who is saying what and why they are saying it. So this is kind of an inside club talking among themselves, but nobody should know what they're doing. The only result we know is nothing is happening. This is not a very transparent process. And there are political implications if you try to project what's happening. But I can tell you one thing. Who started this reform of the Security Council? India, Brazil, Japan, and Germany. Why? Because they are being asked to pay money, resources, and otherwise asked to do all kinds of things in the name of the United Nations, but they have no right to say when to do, what to do, how to do it. Peacekeeping forces and peacekeeping missions are all done by Indians. And Japan pays money, Germany pays money, Brazil, I'm sure, doing a lot in its own way. So they said, look, we are being asked to many things, but we don't get, we are large countries, big countries, we are contributing. Please make us also permanent members. These are the people who started this reform. But who are opposing them? Pakistan says if India wants to be there, I should be there. And if Nigeria and South Africa are going to be there in Africa, you know, there is nobody from Africa now. Nobody from Latin America either. So they said now, all right, if we want to get those people also some representation, and if Nigeria, South Africa gets, Egypt says, I want to be there. And Germany and Japan want to come in there. They are also enemy states originally because they're part of the Axis powers at one time. Italy says, why not me? I should get it. Then when it comes to question of Latin America, I don't know how many other contestants are there apart from Brazil. So these are the people who are now saying, unless you take us also in, you cannot go in. That means if we take all of them in, then if everybody becomes permanent member, then what is the purpose of it? And the Security Council's collective is otherwise gone. And this is the problem of representation versus effectiveness is involved in this thing. And then political dynamics. And now I will just complete that process by just reading very interesting statement I just downloaded yesterday night when I looked at the websites. Fortunately, I got the latest statement of India, Tirumurthy, Permanent Representative of India, speaking on in January 26th of 2021 on this matter. He says, expressing great frustration, he says, the world is not what it was. First of all, he was very frustrated by the continuing stalemate and the principle of silence. And he says, the world is not what it was when we began the process. The objections to moving forward remain frozen in time. Mostly because he added, the process we have is far from normal United Nations negotiating process with no recorded position of states. The G4 nations, Brazil, India, Japan, and Germany, asserted that only two things can save the intergovernmental negotiating as a negotiation group as a format. Negotiations of a single text with attributions reflecting various positions taken by member states in the last 12 years and the application of the rules of procedure of the General Assembly. Describing this as unjustifiable as well as severe constraint on the credibility and effectiveness of the Council, Tirumurthy said, India calls for 6 additional permanent seats, 2 each for Africa and Asia, 1 for Latin America and the Caribbean, and 1 for the West European and other groups, and also for increase in non-permanent seats. That is the latest proposal. He suggested that the need to stick to equitable geographical distribution and not regional representation. He said this regional representation is not a word used in the charter. Tirumurthy also voiced India's support for the common African position as enshrined in Zilvini Consensus and the Sarte Declaration, asking for 2 seats. It may be noted that the African Declaration proposed at least 2 permanent seats, including veto power, and 5 non-permanent seats on the Security Council. It is proposed that the African Union would choose which African governments get the seats, not the General Assembly. So these are the proposals that are going on. All right. Now I'll come to the question of final question I will take is this. The paralysis of Security Council due to delay of the veto is one problem, but then it fanned unilateral acts, interventions, humanitarian and otherwise, responsibility to protect and sanctions imposed by one state against another, accusing internationally wrongful acts on unilaterally and really not by determined by a third party, have proven to be inimical for durable political solutions and lasting peace. This is what happened in the case of Qatar versus the other countries recently, because they accused them of harmful acts. Then this is what's happening when the collective security system failed. But on rare occasions when it was
లేకపోతే నా టేబుల్లో రైట్ సైడ్ సొరుగుండ దాంట్లో పెట్టు.
on rare occasions when it functioned, it created its own problems. That's where the question of judicial review of the decision security councils must be done, and whether this can be done as a matter of existing charter or as a matter of rule of law or as a matter of routine practice, even if it is not expressed, is a matter that has to be discussed. That has been discussed very extensively. And judicial review is also a fundamental to any rule of law in any legal system. Therefore, that is very important aspect which I will touch now. Now, regional and bilateral conflicts are attributed to geopolitics. No longer they are attributed to Cold War. Now they are attributed to geopolitics. This is a new concept that has come about, which incorporates up to a point spheres of influence in its ambit. But now, when the function of the Security Council in the discharge of its primary responsibility is also a cause, because it doesn't follow the limits to which the Security Council, the UN Charter provided that mandatory powers for the Security Council. For example, in the case of Iraq and Libya, while your major role is to maintain peace and security, the forces authorized, because the United Nations does not have any force of its own, because collective security system never is still born in 1945 and thereafter. No military command was given and no agreements were concluded with states to identify armed forces with the United Nations and call in the name of United Nations. So that system never existed. So when United Nations took action, the Security Council in Libya and Iraq, they authorized a coalition of the willing. And coalition of the willing is Canada, United States, Britain, etc., etc. When they went in, what did they do? They did not maintain peace and security. They simply removed the persons in charge. In both places, Saddam Hussein was removed from Iraq and Gaddafi was removed from Libya. Regime change took place. Regime change is not part of the system of the Security Council's authorization and otherwise Security Council powers. So therefore, you authorize force for one thing, and what happens is another. So what is the legitimacy of that kind of action, and how do you question some of these things in terms of the powers of the Security Council itself, which are otherwise binding under Chapter 7 actions on all parties because of Article 25 of the UN Charter. So this question was discussed theoretically because no case has ever come before any court questioning the legality of the use of force and authorization by the Security Council in terms of its powers or limitations on its powers. But I must tell you, the question of the Security Council powers to create a Yugoslavia tribunal came up for review in Tadic case, when it was the first case that took place, was taken by the Yugoslavia tribunal. And then they simply said, as a subordinate body created by that organization, we have no right to question that particular thing. Therefore, they simply did not get into the legality of the matters. So that's what happened. However, I will now let you see what the legal position is. Judicial review of the actions of our authorization given by the Security Council is essential, but so far not undertaken in that sense of the term. Despite the fact that it is inherent in the nature of the UN Charter as a constitutional document, like most others that govern public order at the national level, much authority exists in favor of judicial review of the actions or decisions of the Security Council even if it is not expressly mentioned. Professor Brownlee drew upon the exposition of such well-known authorities of international as Hersch Latterpack, Judge Irian, Derek Bowett, Elihu Latterpack, to conclude that this is inherent in the rule of law is the principle that the law itself should be exercised in accordance with certain standards of justice, both substantial and procedural, adding that in the sphere of international organization, this may be regarded as self-evident. He further noted that the conclusion must be that the Secretary Council is subject to the test of legality in terms of its designated institutional competence. It follows, therefore, he notes that certain criteria therefore apply. Elaborating further, he adds that a determination of a threat to the peace as a basis for action necessary to remove the threat to the peace cannot be used as a basis for action, which, if the evidence so indicates, is for a collateral and independent purpose, as opposed as a basis for action, which, if the evidence so indicates, therefore is only to is such as the one as mentioned, a overthrow of a government or a partition of a state, which is not the objective of Security Council. It is obvious that such a question of virus are clear enough as a matter of principle, provided the evidence of collateral purposes can be marshaled. So one has to get the evidence here, and I think in some cases that's also self-evident that they are contrary to the purposes of the Security Council, and hence it is wrong. Now, I'm still trying to find out some ideas for people who are listening to work on their own later in terms of the rule of law in international law. Apart from the problems associated with the failure of collective security system of the UN, several other complex economic, social, and political factors also contribute to disorder and disaffection in the international society. In the process, maintenance of minimum public order or international peace and promotion of optimum world public order under a universal rule of law based on justice and equity are under severe stress. Some of the factors of concern in this conditioning the contemporary world order are highly globalized economy with capitalism, multilateral corporations with power and resources, in several cases larger than many countries in the world, operating with no social responsibility, evading taxes and regulation, guided primarily by profit motive, foreign direct investment at odds with national public policy, corruption and money laundering running parallel economies, rise of fundamentalism, right-wing extremism or white supremacy, and protectionism, populism, threatening pluralism and good governance, and the rise of non-state actors using terrorism as a tool to gain control over territories, resources, and people. These factors can have direct impact on lack of agreement or consensus among states on several current burning issues affecting peace. Noting that there is a treaty fatigue, it is suggested that the alternative, other types of multilateral instruments adopted included G20 declarations, memoranda of understanding, heads of state declarations, among others. In addition, as one observer noted, backlash to international law in general to some treaty regimes in areas such as human rights, international criminal court, free trade agreements, or investment treaty arbitration is also very much in evidence. Migration of people from one country to the other for better life and employment is one indicator of an interdependent and international community. But at another level, there is migration of refugees because of persecution, conflict, violence, human rights violations, and even seriously seriously disturbing public order. The gap between the poor and the rich is ever widening, not only among states but also among people within states. The COVID-19 pandemic started us about the inequality and iniquity that is dominant in national and international societies, leaving millions of people helpless, facing life and death issues every day. I just read again yesterday or today paper, I don't know, in India, thanks to pandemic, the employment of girls is extremely in jeopardy now, and their share of employment has gone down already, and for them to find employment in a situation like this, it's most difficult, and it's a matter that has to be really addressed seriously in India, because you and we know, now I'm talking to people in our own state and our own country, we know it's our girls who are managing most of these internet operations, most of these banking operations, most of these public service operations, hospitals. Everything is done by our girls and sisters and daughters and mothers, and these are the people who are working there. And now they have lost jobs and they're not getting the right kind of, again, fillip to come back. And this is a grave problem that is going to face in terms of gender equality, in terms of employment and human dignity. Now, cyber attacks. Every day we see cyber attacks. Now we have Pegasus going on in India, and it's not an attack, but it is a kind of a system by which your privacy is taken away. Cyber attacks are so many places is taking place, and of course the entire Qatar dispute is on account of cyber attack and accusing them of terrorism, etc. So I will not go into the many methods by which cyber attacks are taking place and how seriously they are working. But the problem here is, how do you handle this cyber attack? And there are some principles here, but most of these principles are not in a manner that would help a rule of law situation. They are only trying to take what you call self-help type of situations, and mutual deterrence type of situations are being practiced to deal with these cyber attacks. They are not regulating the internet systems. They are not ready to deal with cyber attacks as an domestic order of good governance and ensure that their territories are not being used by some of these people. Because computers are in one place, person is sitting somewhere else, and then you're hitting some of the targets also. It's difficult to regulate them in any particular in that sense of the term. However, the cyber attacks, as I told you, essentially deterrence and self-help is what is being practiced, but we need to really move beyond that if we really want to control this serious situation of cyber attacks. But now we come to certain final points, because I think we have taken a lot of time already, and I would have gone on to deal with many other matters if only one has time. But now some further thoughts, some thoughts for further reflection by way of conclusion. The problem awaits solution partly because I'm talking of cyber attack. Certain attribution of responsibility to any one or more sources is difficult. Any action by way of countermeasures, as in the case of dispute between Qatar and neighbors, is likely to be adjudged as unlawful. On hacking and cyber warfare, states are unable to come to an agreement to prevent them or adopt systems of verification, even if some agreement is negotiable. Advanced states like the United States and others adapt on techniques of defense and deterrence in dealing with issues related to cybercrime and hacking. There are some principles in the nature of soft law, like talent principles, that are considered useful in a limited way to respond to the problems created or concerns raised by cyber attacks. The developments noted above involving concerns as well as solutions attempted are offered highlight the interdependency and highly interpenetrating in character of the world social process affecting power, wealth, skills, enlightenment, or knowledge, affection or human rights, and requiring rectitude or responsibility on the part of all participants in the process for common good. There are no sectoral solutions for the protection of environment, for peace and security. There are no shortcuts, short-term solutions for a planet so small and so fragile. Limits to growth are clear but ignored, are not given the due regard it requires, putting in danger the very survival of humankind, having already put at risk so many other species on an unendangered list. The international community is a fact. Human behavior and national and international governance is not in sync with this inescapable reality. Protection of environment is possible if we collaborate and contribute to sustainable growth, for realization of which a lot of work has already been done. We have the means, but we need to muster the necessary will and power willpower with self-discipline. A sense of sharing in a wider but ever-shrinking world is the prescription. As for international peace and security affected by terrorism and unilateral interventions, insofar as they are linked to existing power, hegemony, and maintaining spheres of influence, answers may lie in the fact that the bigger countries are increasingly realizing their limitations to manage unrest and strife elsewhere at a time when they have become a serious threat at domestic level itself, at their own domestic level itself. With the US withdrawing from Afghanistan and Iraq after years of engagement there, and the kind of domestic terrorism that it is facing currently is a pointer in this direction. The threat or use of nuclear weapons in a situation of conflict poses a less serious problem than damage that they could cause by human error or accident in handling them, apart from constant vigil that is required to prevent them falling into hands of irresponsible terrorist groups who do not have any respect for life. Several boundary and border disputes could easily be solved as relevant principles to settle them peacefully, either bilaterally or through judicial settlement, are clear and employed in several cases, including the maritime boundary delimitation between India and Bangladesh, which was pending for nearly 30 long years before it was resolved through arbitration. In such matters, disputes remain unsettled not because the legal problems involved are intractable or otherwise not available, but our means are not available, but more because of lack of political will to yield to legal solutions. And some people thrive on conflict, in fact, that's what some people told me when I asked a long time ago why certain disputes never get settled. They said that they give jobs and opportunities for some people. Management of problems of minorities and domestic terrorism are issues linked to respect for human rights, equitable representation, equal opportunities on one hand, and good governance on the other. Management of problem minorities can be solved in those terms. Most other problems associated with globalization, xenophobia, migration, racial and gender discrimination are serious, but not serious enough to halt the march of rule of law in international relations as they are now, as they are not at the national level also. Problems associated with climate change and current pandemic have proven serious enough for human well-being and health, but answers for them will be found in science and technology and international cooperation. The needs of the poor and weaker sections must, however, be given high priority as a matter of equality and justice. The current pandemic and the process of administering vaccination across people within and across states taught us a lot of lessons that there is need for global good governance apart from good governance at the national levels also. It is my hope that India would be seen as a leader in the revival of humanism and combined with spiritualism in these troubled times to give new lease of life to rule of law both at home and internationally. I thank you all for the very patient hearing you have given, and I hope in my rushing of the ideas I have not imposed myself upon you in any unwieldy way. I thank you very much for this opportunity I got. It's a humble presentation. I do hope this will help my more learned colleagues who are listening to help us with better solutions and with greater scholarship and engagement with these matters. I thank you, and I thank Andhra University, and I thank the opportunity, all those organizers for holding this particular endowment lecture in memory and in a spirit of seeking further inspiration from one of the greatest sons of Andhra University Law College, Venkataraman. I must say this one point. 3 persons from Madras came and they became hallmark of our excellence in Andhra University. One is P.S Rao, S. Venkataraman, and Mahadevan. Can you imagine that in a composite Madras, if we went to Madras and then tried to develop that side of the state, they came to us in a remote area like Visakhapatnam those days, and Bandar, of course, etc., to help us and give us a life in education and an opportunity to think and somehow navigate through difficult times in our life. May God bless the great memory of those people, and we must continue to inspire by these souls. And once again, my humble pranams. మీ అందరికీ ఎంతో ధన్యవాదాలు ఈ అవకాశం ఇచ్చినందుకు. Thank you very much.
Thank you so much, sir. So probably I have no words to say. That has been an excellent erudition, and you in a way threw us into the ocean of international law and have helped us swim through also. So it has been a great learning experience, sir, for all of us. So thank you so much, sir. I understand Professor Gupteshwar Garu is online, I'm told, and then he sent, sir, with the permission of the chair, Professor Krishnamohan Garu. Professor Krishnamohan Garu, can I say a few words, sir? Just 2-3
Yeah, go
things.
ahead, madam. Go ahead, madam.
Sir, Professor Gupteshwar Garu, he has sent me a message and he said he would be happy if I can read it out. So this is with reference to Professor S. Venkataraman Garu, and he wrote, I offer my humble pranams at the lotus feet of our great Guru, Professor S. Venkataraman, in whose name the first endowment lecture is being delivered by the international jurist and distinguished legal advisor, Dr. Pemmaraju Srinivasa Rao. I fervently look forward to the mellifluous oration. So this is the message he has sent, sir, and I understand he is there online. So another nonogenarian who is a direct student of Professor S. Venkataraman, J. Surinarayan Garu, who is a senior advocate, and he says he taught us Hindu land contracts, other subjects, and there is every reason for me to be grateful to him for my career. And he said he was mesmerizing while lecturing to us on the subject of contracts, and I shall be grateful if you can read it out, he said. So, sir, this is like a combination of a worthy teacher and a worthiest disciple delivering a lecture in his memories. So, I'm sure my students have richly benefited and they have thoroughly enjoyed everything.
I'm waiting.
Can I now? I request Professor Venkatrao Garu to share his reflections. Can I? Professor Venkatrao Garu. Professor Venkatrao Garu.
Yeah. Am I audible?
Sir, you are audible.
Yes.
Sir.
Yes, sir. Sir, we were spellbound.
Right.
You were an intellectual powerhouse of high voltage. See, if there is something greater than the earth, that is the ocean. But if there is something greater than the ocean, that is Pemmaraju Srinivasa. Like the manna flowing from heaven. That's right. See. And I had the privilege of witnessing a marvelous function where former students of Professor Venkataraman fell at his feet. Just 6 months before he completed his voyage, he came to room number 28. And students led by D.V. Subbarao, remember, that was the meeting in which this endowment was established, instituted in Andhra University. And Professor Venkataraman must be blessing from the above, sir, remember. And we are grateful to you for reminding us of the excellent legacy that this institution has on 4th August, a day on which this institution was baptized. Thank you very much. My grateful thanks to Principal Madam. Thank you very much.
Thank you, sir. I understand Professor Gupteshwar Garu wants to say.
Hello?
Sir, Professor Gupteshwar Garu wants to say something. Sir, Master, namaskar andi.
Namaskar.
It's a great
Thank you.
to
Thank
see
you for giving me the opportunity.
Yes, sir, it's a privilege to us.
Professor Sumitra.
Sir.
I am speaking from Philadelphia, my daughter's place, where I have just had the pleasure of listening to my dear P.S Rao's oration. Most befitting, I congratulate you and authorities of the university for inviting such a great son of the university and the college to deliver the oration in the name of our great Guru, Sri Swaminathan Venkataraman Garu, who granted me and a few others in the campus, we sprouted and flowered into what we are today. And we hope we have proven worthy of being his students. I am very happy and I am very thrilled to listen to the peroration of my dear Dr. Ramaraju Srinivasa Rao, a product of Andhra University as well as Yale University, and a great luminary at the international level. Well, I am fortunate to be able to participate in this way, in this grand function. Srinivas Rao, I am really thrilled. I listened to your oration. Really, it was not just a speech, it was an inspired oration, partly because of your learning and partly because of Venkataraman. Thank you.
Partly because of you. Partly because of you.
Oh, great, great. Andhra University is.
You are a great teacher, great teacher.
Oh, thank you. Thank you very much for remembering. And you have grown sky high, sky high. And you are a native home son. And you hail from our area and Guntur and then Geneva.
Thanks, Master.
Thank you.
Thanks.
Thank
Your
you.
blessings. Your blessings.
Admirable speech I have heard. And I congratulate Sumitra and her colleagues for the excellent choice. Thank you for obliging.
Thank you so much, sir. And in fact, it's a privilege that you speak to us on this occasion and we could interact with you. And it must be late night or something, early morning. So we chose to be awake and then bless us. Madam, namaste.
Namaskar, madam.
నమస్కారం నమస్కారం నేను మా ఆవిడ కూడా విన్నాం అంతాను అండ్
నమస్తే అండి నమస్తే
శ్రీనివాసరావు ఇంటికి వెళ్ళడం కూడా నాకు వచ్చింది
It's like a family gathering now.
And my dear Venkatrao also is there.
Sir, your blessing. It's greatest evening, sir, for me here.
And
Even Ramarao, S. Ramarao is sitting there. He said he will also be participating.
Oh, another star from New York.
So then I take cognizance of the presence of many other scholars and stalwarts, who are vice chancellors of other DS, Professor Surya Prakash and Professor Rajendra Prasad and Professor Chandrakala, Dr. M.K. Rao and Mr. Badrinath. And then there are Professor P.V. Subbarao Garu and Professor Hargopal Reddy Garu. And then all of them are Professor Jagan Mohan Rao Garu, especially.
I'm glad you have mentioned their names. I'm glad you have mentioned their names just now. I'm equally thrilled.
Professor Jagan Mohan Rao Garu is and Professor George Joseph and Professor Hemalata and many others are there. And because it's online, probably we couldn't take cognizance of the presence of many other distinguished alumni and other scholars. So before we once again hand over the proceedings to the Honorable Registrar, our Vice Chancellor, or in his absence, to Professor Krishna Mohan Garu, the Registrar of Andhra University.
Krishnamohan garu, namaste. Namaste, Krishnamohan.
Namaste, sir. Sir, it has been so nice at this age. You have agreed to deliver the prestigious Professor S. Venkataraman Endowment Lecture on the topic International Rule of Law, Problems and Prospects. I think today's your lecture is definitely very inspiring, informative, and thought-provoking. The fact that several of the legal luminaries who were there online with their blessings to make this endowment lecture delivered by Dr. P.S Rao garu, an international figure, special advisor, Attorney General Office, State of Qatar, and former member International Law Commission. Really, your presence on this endowment lecture covering so many aspects under the international rule of law, right from how the international law as distinct discipline, different from national law, and also essential features of rule of law, and how rule of law as a product of world social processes and the contemporary world order and international rule of law and evolving principles. What is impressive is coverage on protection of environment and compatibility and the combating the climate. Today, the climate change has been hot topic of the discussion, and what international law speaks on this issue in the wake of protecting the environment. All around, there are issues covering green aspects. Everywhere, there is a discussion on the topic of protecting the ecology, the environment, leading to sustainable development. As we know, the relation between law and the society, definitely the points that we have thrown open today is going to ignite the minds of the policymakers, the lawyers, both at national and international level, and also the researchers now and future. Your valid inputs are going to go a long way in building proper understanding as well as research leading to simplification of these issues, which we have discussed at length. Your lecture today is such a comprehensive, and I really congratulate the organizers for bringing such a expert and legal luminary who has delivered a very useful, productive, successful endowment lecture. Undoubtedly, this organization of this endowment lecture has improved the image, the recognition, the status of Andhra University, especially the Department of Law, the college, Dr. B.R. Ambedkar College of Law at Andhra University should place its appreciation for all the efforts that were taken uninterruptedly, 3 long hours at this age, really deserve
I told you when I start speaking, it
Did not even
You
have
know, almost, sir, almost all of the participants are captive audience as a witness and also appreciation. There are many gurus. In fact, when I joined first year of law, Professor Gupteshwar, he interacted with us, although he was not a teacher, 5-6 sessions he has taken. And Professor R. Venkat Rao was also my teacher. And there are many, senior professors with whom I have the acquaintance. And especially Professor Gupteshwar is appreciating and also thanking you on behalf of Andhra University. And as a student, as an alumni of Andhra University, you have enhanced the pride. We feel proud. You being student of Andhra University, gone to such a pinnacle in your career, in your profession, you richly deserve our appreciation, and definitely you brought name and fame and laurels to Andhra University brand image. You are our brand ambassador and richly deserve to be the endowment lecture that you have delivered today. We promise that your inputs will be taken with all that seriousness in pursuing your thought process into the further heights, make this society peaceful and progressive. And I need to thank the organizers and also all the participants and the well-wishers and the galaxy of legal professionals and the luminaries in their own field who attended and made this endowment lecture a grand success. Thank you all for giving us the opportunity. Thank you very much, sir.
May God bless you all.
Thank you.
Namaskaram to my Gupteshwar Master.
Can we stay in the meeting for a little while after?
ఉండవయ్యా కంగారు పడుతుంది.
Registered Garu, we may continue in this meeting for a few more minutes.
Yeah, I'm available. I'm available. As long as you want, I'm available. You must take your time.
First of all, మీరు కొంచెం గ్లాస్ మంచినీళ్ళు తాగండి.
Sir, you have become an inspirer. See, at this age, when you are able to deliver so long lecture, and I am really amazed to take note of it, and you are source of inspiration to many of teachers like me. And today, really, I cannot digest how you are able to speak 3 hours long in such a complex subject and in a lucid manner. The way you presented.
Let me tell you a small story now that you are in informal mode. When I first joined the law commission, and I'm sure my teacher Gupteshwar will laugh also. So I just so that all of you can laugh also. So when I joined the law commission, first time that was 1987. I was a very young man, 42, 43 at that time, and 45 actually. And then the kind of people who were already sitting in that commission at that time were Mahan Bhavul and Taman Telugulo. Kuchunaranత పెద్దవాళ్ళు. We went there as a small young man there. Bhopal gas tragedy took place just the previous year, 84, 85, that kind of thing. And the discussion was liability. This is a subject which I did thanks to Professor Gupta's orientation to me way back in the tort law, etc., which I started taking interest in it. And Bhopal gas tragedy has taught us a lot of problems about this transboundary harm, damage, etc., how to handle it and what not to, who is responsible. Chernobyl accident took place before. So when my turn came to speak, and the first opportunity I got to speak on the subject, I was never used to write down in notes and then speak only that particular 10 pages or 5 pages or 4 lines or 10 lines. I'm always an extempore person. And that day it so happened that I was the first speaker. And normally the law commission's tradition I did not know because I'm new. 10 to 11:30, there is a one session and there's a coffee break. And this 1.5 hours, there are 4 people, 5 people, or even sometimes 6 people will speak depending upon the topic they're talking, 10 minutes, 15 minutes, 20 minutes, very, very organized. I come and hear, not knowing any of these things, talking to the people who are already spending nearly lifetime in the subjects and otherwise, much older than me and much more senior in many, many ways. I sit there and start opening and talking. I did not know the timing. It went on for the entire morning session of 10 to 1:30. And the chairman, of course, all of us are equal as members, so they will never say, no, you have only 20 minutes to speak, you cannot speak like that, they cannot say that. And then I'm talking about Chernobyl, this Bhopal gas accident, which is a matter of great importance to our background and India. And went on and went on and went on at 10:30, 11:30. Then chairman said, Dr. Rao, can we break for a customary break? Can we take for a cup of tea for 11:30? If you want, you can continue later. And then I said, no, I'm so sorry. I did not realize this. So I apologized and I concluded my statement and I closed it. Then when we were going to the coffee, the senior most person, we call him Doyen. The Doyen of the law commission at that time was one Calero from Brazil, very, very dear friend of us. He was our leader in the law of the sea conference also. So he came to me and many others are congratulated. Oh, you spoke very well. You did, oh, very nice, etc., etc. And then, oh, you told us so many things about this Bhopal and what's happening, this, that. And then this senior person comes to me and says, puts his hand around my back and says, Mr. Rao, you know, what all you said, we already know about it, he said. Then I told him, just like it's always true also, because humility is not something that we acquire. It is important because we are so limited in our knowledge. So we are always humble. So I told him, sir, don't I know that you know everything, but I thought you should know I know a little bit also. And he said, you rascal, he said. But then it's not a rascal business. It's actually a natural thought that occurred to me, because what happens to you when you're a mother and a father, when a small child goes to school first day, he comes back and you ask him, what did you learn today? And he will tell you, all those things he will be telling as if, he has learned something very nice and something new, and you will be listening with great amazement. Oh, you learned that. It's exactly that. When you're talking, it's not that others don't know what you're saying. They should know that what you are trying to learn, that's all. And I think this lecture is also in the same format. I'm trying to learn every day. I think you people know it already. Thank you very much.
I mean, precisely, and we are the beneficiaries, sir. The best kind of thing that we might think of is listening to you, sir. So, I mean, I have probably no words to thank you, sir. I thank you profusely again and again. And sir, Dr. Rama Rao garu wants to speak.
Yes.
P.S Rama Rao garu.
Thank you all, and good afternoon or good evening to India, and good afternoon to P.S Rao garu in Doha. Can you guys hear me?
Yeah, very well, very well.
What a pleasure indeed, though. But it is, I just wanted to say hi before you close the meeting, and particularly wanted to also express that Professor Gupteshwar garu is sitting there, and what a pleasure indeed to see him. It's quite some time since I last saw him. Anyway, what a great topic it is. I say, speaking about, I know you told me, and Professor Sumitra, Principal Sumitra sent me, which I saw late in the night last, in any case. I've been up here from the morning. I didn't want to put my video at all, but I've been like, what time, 3:30 that I woke up, and now it is 8:30. It's 5 hours that I've been up. And I've been wondering how Gupteshwar Garu has got up so early and sat in the chair along with Madam there. Anyway, what a topic it is indeed. I say rule of law at international level is some. I mean, I think it's really phenomenal in terms of the endowment lecture for you to have chosen, P.S. Rao Garu, for you to have chosen this topic. It is. I think it is. I mean, it's worth now the next magnum opus of yours. You can write a 700-page book on this. I mean, I know you have. Yeah, but you are typing in any case faster and much more than I do. I'm more still a pen, pencil, paper guy. And also after I retired in the last 8 years, I really forgotten all this, my office and my computer and all that. Anyway, but again, getting back to the topic, I think it's really phenomenal. You surveyed from 45 onwards till now, of course. You also referred to 1800s and the whole, and then even Westphalia and all that stuff, the church and state, and till today, till the Security Council reforms and all that. But what a great overview, I mean, deeper overview of the landscape of international law in terms of, once you say Security Council, in terms of decision making, composition and structure, and the specifics of from power politics, power being the center of politics of Morgenthau realistic school to whatever your New Haven school to whatever. Hats off to the great general survey and occasional deeper issues understanding. And what a pleasure indeed it is. And you knew you were a student of Venkataraman and I was not. And of course, Gupteshwar Garu is a witness to, the whole history of Law College, the whole history of the Andhra University Law College. I'm an old guy speaking about the Andhra University Law College, not the B.R. Ambedkar, who we all respect. So I'm moved. It is phenomenal. And I think as you have said, you have left several issues for the next generations to follow in terms of picking up for greater research, further research on the aspects of judicial review, as you say, a rule of law reviews of power at international level. Well, you covered it till Afghanistan and Iraq and all that, and we are all responding to even the current situation today, in addition to what you have grown in 60s and what I've grown in later in the next decade from then on. I just want to congratulate the organizers, particularly Professor Sumitra and the Registrar and the Vice Chancellor and everyone of Andhra University. And of course, kudos to you. I mean, I cannot imagine that anybody else will do this justice to this topic except you. It just takes some 60 years of international law experience, and I think about 40 years at the international level, or really 40 years from the ILC onwards. And really, I mean, for me to appreciate you is like somebody from the family saying kudos,
Exactly.
and
Exactly.
people will think that it is like each one like
Patting one's back, patting each other's back.
patting one's back. But then for me, I'm really moved and really sincerely and honestly appreciate. And I have, of course, been with you all through my journey as you being my older brother, from anywhere to anywhere, from JNU to, of course, EL being missed by me, but then to Madras and to the UN and the rest of my life. And today, all the time.
Thank you.
So I congratulate you, P.S. Rao Garu, for what a great lecture. And I really, really think that it is one of the greatest lectures for any endowment, and particularly for this endowment. And it's a great contribution to international law. And I think I'm taking a longer time. And Masharu Gupteshwar Garu, Namaskaram. And then it was also a pleasure for me to see Jaganmohan Rao Garu. Like I haven't seen him quite some time since I last visited. I don't know if he's there, but I saw him in the beginning. And of course, I recognize all, like Venkatrao is sitting there, Rajendra Prasad is driving the car now. So he was sitting in the beginning, and now I see Professor Rajalakshmi, and I see so many of all our colleagues, friends, and of course, again, Mashariki Namaskaralu once again, and thank you, and what a pleasure indeed to listen to this. And it is worth not having slept this night. Thanks.
Thank you. Thank you, Garu.
Thanks.
Sleep well now, and sleep well now.
Sir, then there is Krishnamohan garu లేరండి పేరు అంటే మనం చెప్పాం కదా ఆయన వెళ్ళిపోతాం అంటే we will stay back అని sir, Dr. Ramani from South Asian University, she wants to say a few words.
Sure.
Ramani,
I'm available.
Sir.
I have no particular urgency.
And we are troubling you, I understand.
No. For me, this is my normal time, so keep taking it. I love it.
Ramani?
But others
Yes,
those who do other things may have to really. But I'm with you.
The students, I mean, this is only an informal gathering, and the meeting, the formal.
Now it's informal. Now it's completely informal. Yes. Go ahead. I'm with you.
Sir,
Ramani?
namaste, sir. Namaste, sir.
Namaskaram.
సార్ చాలా రోజుల తర్వాత మళ్ళీ మిమ్మల్ని చూస్తున్నాను 7 years తర్వాత 7 years బ్యాక్ మీరు SAUకి వచ్చారు.
అవును.
So just one question, sir. Actually, I'm talking in the background of two writings on IROL. One, Professor James Crawford in Melbourne Journal of International Law, and one, your own writing on fragmentation in Michigan Journal of International Law. So given this increasing fragmentation of international law, and especially the kind of diverse interpretations that are coming in from the arbitral tribunals, non-ICSID arbitral tribunals, how do you look at substantive international rule of law? And do you think that we can actually go much farther than having these, transparency measures and all these kind of things? Now, I'm asking this question right now because UNCITRAL is heavily occupied with ISDS reform. So in that background, how do you look at it? What is the kind of course that you would be suggesting? I mean, given that you yourself are aware, have contributed so much on fragmentation.
Well, basically, issue of fragmentation of international law is, I think, a problem that arises because of the specializations that have taken place, which I have already mentioned in the Michigan Journal.
Yeah.
But then the problem is nothing so special or something new or otherwise so intractable. It's one of those. Technically, it's a manageable issue. It exists, but it's a manageable issue. For example, as I told you in my lecture today, in the Tadic case, the International Criminal Court, not only in Tadic, Kadi, and the other cases are also there. The International Criminal Court is taking one type of a position as far as overall control is concerned when you are attributing command control responsibility problems. If you have an overall control, you are responsible also, apart from the person who's doing it. The person who is in the overall control is also responsible, individually. But when it comes to state responsibility, the court has dealt with that matter and said state responsibility is much more integrated with law of agency and operational systems. And it requires, and many more multiple objectives also involved in state management of any particular context. So therefore, in order to attribute a wrongful act, of a private individuals or otherwise agencies. Agency is different from private individual. Unauthorized acts are otherwise also attributable to the under law of agency to the person who is authorizing. But in the case of private individuals and other acts, the effective control was the thing. So therefore, there is certain amount of, in other words, it's just like fragmentation. If you put it in a very legally and in a very, as a decision maker, as a judge, you are sitting in a court. Somebody else said something else and you are now coming to something else. You try to deal with it both as a matter of interpretation, as a matter of distinguishing the facts and situations, so that you can, like precedent, for example. Precedent in national systems is binding. Supreme Court decisions are binding. But then they differ, the lower courts differ by showing a kind of a twist and a kind of a difference between the two, and then try to go into their own decision making again. Of course, they come for appeals later again, and they can again, and then again that and one bench can disagree with other bench. So if that is not fragmentation and that is not otherwise a problem, why is fragmentation is a problem in international realm? In other words, if a tribunal or an arbitral tribunal particularly, the problem is essentially with arbitral tribunals, as you rightly said. In the case of investor-state arbitrations, no two arbitrations give the same opinion on how to interpret the most favored nation clauses, the objective and purposes of their clauses, to assume jurisdiction and to arrive at certain conclusions also later. And no two, each case by itself. Similarly, in the case of maritime boundaries, in which I have had some involvement, it's also the same thing. No two cases you cannot draw any conclusions. So therefore, while the underlying principles and the basic philosophy of law will have to be promoted and respected and developed and continuously be integrated into the totality of the decision making, but individual facts and an individual circumstances which are otherwise determinant for coming to application of law and interpretation of law, they can always change depending upon what facts are. So to that extent, fragmentation is, to my mind, is not a serious problem, but I think it's only a question of coordination and concordance, and then respect for the specific facts of the case. And that's where the fragmentation is, I think, arises and not so serious. Thank you.
Thank you, sir. Sir, let me now introduce to you, sir, my esteemed colleague, Professor Vijayalakshmi. She is Professor Vijayalakshmi Indi, and he is Dr. L.V.K. Prasad. And Professor Prakash Rao, anyway, you know, he is here till now. And then she is Dr. Pallavi and Dr. K. Sita Manik. Sir Rajendra Prasad garu. Rajendra Prasad garu, I think he not available. So driving. Okay. So I mean, anybody, if they want to interact or say something or add something, now it is open. Rajalakshmi, Professor Rajalakshmi. Professor Rajalakshmi is there? She is there.
Namaste, sir.
Namaste, namaste, ma.
Professor Rajalakshmi is there.
Namaste, sir.
Namaste. Nee pustakam ratri mali chadiva.
Simply I have no words, sir.
No.
Because,
But I think your suggestions are very well. Your suggestions are well taken to elaborate on the reform of the Security Council as well as on the two matters that you wanted. You know, the Security Council regime change versus peace and security matter. I think I could only do that thanks to that input from you people, and I'm happy to. And I learned also again what's happening with Tirumurthy's statement. I got a hold of it last night only. Very good, very good. Congratulations.
Thank you, sir. Thank you, sir.
చాలా మంచిదమ్మా.
It's a great privilege to hear your lecture, sir. Very
Some people ask me, how come you are still looking so young? I said, no, when I go to bed, I don't know, I know my age, but what keeps me young is I'm always trying to understand why this is happening like this. Because I don't understand myself, so I keep learning. And my teachers have trained us forever, you are a life student forever. And that helps us. And that keeps us going. And thank you very much for your book. Once again, last night.
Mute అయింది సార్. మ్యూట్ లోకి వెళ్ళారు
సార్. మీరు కొంచెం అన్మ్యూట్ చేసుకోవాలి సార్. మీది మైక్ మ్యూట్ లోకి వెళ్ళిపోయింది సార్. పిఎస్ రావు గారు, మీది మైక్ మ్యూట్ లోకి వెళ్ళిపోయింది సార్.
ఓకే, నౌ ఇట్స్ ఓకే.
ఇప్పుడు వినబడుతున్నారు.
Basically, we stay young because in spite of our body and constantly rebelling against us, hands, everything, is painful now. But nevertheless, when you look at a point, you don't understand why this is happening. You don't understand what are the complications involved, why this becomes so serious, and why this cannot be solved. So you ask these questions, like many questions are presenting us, and you start looking around things. Your mind is active, and as long as your mind is active, the body takes you up to a point. I said, and our teachers like Gupteshwar, my own brothers and others who are older to me, they are active and they are constantly, doing the best they can under the circumstances. So that gives us a lot of inspiration. Thank you very much. Thanks for your work also. Thanks for it.
థ్యాంక్ యూ సో మచ్ సార్. మేము మీకు శ్రమ ఇచ్చామని అనిపిస్తున్నది. అంటే మీరు you have taken it so seriously and worked so hard that at one point of time I felt, am I troubling you?
No.
So thank you again.
And I'll finish that the note also a little more quickly and then give it to you, no problem. And Master P.S Murthy garu mana Gupta sir పంపించావు కదా నా ఆర్టికల్.
పంపించాను రామారావు గారికి పంపించాను.
రామారావు సరే పాపం అప్పుడు అడుగుతూ ఉంటాడు
సార్. మీరు కానీ అంటే మీరు ఎప్పుడు అంటే అప్పుడు పబ్లిష్ చేస్తాం సార్. ఇట్ విల్ బి పబ్లిష్.
నేను మీరు చూడండి, మీరు కూడా కాస్త వన్ మోర్ టైం చూడండి. ఇఫ్ దర్ ఎనీ పాయింట్స్ ఐ విల్ యాడ్ టు దెమ్ అండ్ ఐ విల్ వర్క్ ఆన్ దెమ్. And if my colleagues who have, you can share it with others who are interested in it. And if they have any points of view from their point of view, I will look into it. Like you have helped me with 2 ideas, which I was able to quickly bring in, and I will do my best. And we'll work on it together. And with the blessings of Gupteshwar and my, of course, Nenu Ramarao, constant dialogue.
Madam, thank you.
Hello.
Lecture ఇన్విటేషన్నందుకు థ్యాంక్ యూ సార్.
Sorry, did I interject? Somebody was speaking.
No, go ahead.
ఇప్పుడు what are you do? Can you hear me?
One second.
హలో, ప్రొఫెసర్ సూర్యప్రకాష్ గారు ఫ్రమ్ DSNL, వైస్ ఛాన్సలర్. వాయిస్ sir. Then I think we should let you relax now at least, sir.
No, Ramarao wants to talk something. Suryaprakash garu vachinattu chudu.
Suryaprakash garu చెప్పి సార్. రాజేంద్ర ప్రసాద్ గారు.
హలో
హలో మాస్టర్.
మేడం
సార్
మటన్
విన్నారా సార్? ఏం సార్
పెట్టారా?
మీరు ఏమన్నా చెప్తారా? మాట్లాడతారా సార్?
చెప్తానండి. నమస్కారం చెప్తాను నేను.
నమస్కారాలు చెప్తున్నారా?
Sir, very nice to hear you, sir. Yes, I am not that much, well versed with all the principles of international law, but I was able to follow what I was said about self-determination and other issues. We are really, our college has a proud alumnus like you, and I know that you are my mentor and also guru in many respects. And I always take you as my role model as far as your
We are all fellow travelers. We are fellow travelers.
as far as your simplicity and also, just your knowledge in this particular field of international law. I remember the way in which you blessed me when you visited our university. That is, our university means as a Nagad University when I was serving as vice chancellor. So I had wonderful moments there with you. So thank you very much, sir, and for your very nice lecture today. Thank you, one and all. And also thanks to the law college for giving me the opportunity to say a few words about the great scholar, Dr. P.S Rao garu. Thanks, madam.
Law college Balanta P.S said the alumni.
Ramarao wanted to say something.
Sir, Ramarao garu.
Nothing. I was going to ask about the follow-up of this. Would it be, how are you going to follow it up? I think I can talk to you separately on this.
Yeah. We will. What I would appreciate is each one of you, particularly you, Ramarao, you have a lot of experience with you and many other areas. I know him, so he's too. If you tell me I am modest, he's even more modest. He's even more modest. But I tell you, I like what he has to say on anything. And if you or anybody, the S.Venkataraman Endowment, those of you are interested in reading this thing, particularly Ramarao, of course, to see if there are any areas in which, of course, I put a lot of material in the footnotes. Normally, do text lo koncham unchi ekku footnote lo తీసుకెళ్తాను. Generally, it's my habit adi. But if you feel like changing any of those nuances, if you want to bring more something different and something more and something you know and I don't know, and if you can help me improving some of these things, I'll be more than grateful. And then let's make it a kind of a note or a paper that will be published in the name of that great man, but would be of help to the younger people to see what kind of areas in which they can do further research and can take some profit from it. That's all.
Fantastic. I think you are. You know what I see. What I'm more impressed with is not only that this is as I said, what I would now call a historic overview of incisive nature of the entire evolution of international law, and particularly the post-war time till now, but also you're opening up entire new chapter for further research for future. I think that is what I guess. We can talk more, and of course, I will listen to you.
We'll do that. We'll do that.
But I would say that this is. But I think because you are more practical than I am anyway, so I think it should see the publication day of light of the day ASAP as soon as possible.
We can push it faster because I have completed my research. I don't.
Absolutely. Anybody else commenting? Anybody can comment. Like I can say that and this, but it means nothing, honestly.
No.
It's a matter of you taking a second view.
It's a question of detail and the concept.
Yeah, like those can go on because that's what the further research. Anybody else can follow it up, but I think it should. You should bring it out as soon as possible, immediately.
Thanks, absolutely. I will share my latest. I will share my latest. I will go through some more things and then I will share it very quickly within the next tab as soon as possible, so that we can get it out in publication.
Absolutely, I think it's worth it. And again, congratulations.
Thanks, Nana. We will
thank you. Thanks.
And thank you very much, all of you, for the time you have spent with me.
Publish it, sir.
I did not know it went for 3 hours, huh?
లేదండి, అంటే మనం స్టార్ట్ చేసేటప్పుడే కొంచెం లేట్ అయింది. అరౌండ్ 3:30 అరౌండ్ 3:15 అలాగా స్టార్ట్ చేశారు.
No, it's exactly 3 hours.
ఇప్పుడు 7 అయింది.
exactly 3 hours.
And including our informal chat.
Yeah, yes,
No,
yes,
manchi,
yes.
manchi. No, I think you should all retire and then enjoy yourself. Well, this is enough. Thank you very much.
Yes,
You have given me a great feast. You have given me a great feast. Thank you very much.
So
Good
much
night.
thanks to Madam Garendi.
ఎవరు ముందు మా గుప్తేశ్వర గారికి నమస్కారాలు చెప్పుకుంటూ మనం
Sir, అందరికి.
నేను మళ్ళీ మాట్లాడతాను గుప్తేశ్వర గారితో separate గా
All of you. I once again thank all the participants for making it a grand success. And apart from the speaker, apart.
Okay. Master, namaskaralu. Thank you.
Namaste. Namaste.
Namaste.
Namaste.
Sir.
You are an inspiration for us, sir. Thank you.
Master. Thank you, Master.
Namaste, Andy.
It's a great day. It's a great day for me. Great day.
Srinivas Rao garu, namaste.
It's a great day because it's like a family talk more than an endowment lecture, more like a...
Yeah.
Thank you very much. ఉంటాను మరి మళ్ళీ కలుద్దాం.
Right, sir. Thank you. Thank you.
Thank you.
Namaste.